the Philippines' #1 news channel. Ito ang GMA News TV.
Magandang hapon po, Day 21 na ng makasaysayang impeachment trial ni Chief Justice Renato Corona. Ako po si Ivan Mayrin.
At ako naman po si Cara David. Samahan ninyo kaming muli sa special coverage ng GMA News TV. Ito ang The Chief Justice on Trial.
At patuloy tayo magbabantay sa mga pinakamainit na pangyayari sa Senado.
At mag-uulat mula roon ang ating kasamang si Joseph Moro.
At dito naman po sa studio, makakasama natin ang isa pa ring legal expert para gabayan tayo sa proseso ng impeachment trial ni Chief Justice Corona.
Ikinagagalak po nating makasama ngayong hapon si Attorney Victoria Avena ng UP College of Law, isang eksperto sa evidence legal history at civil procedure. Magandang hapon po, Professor Avena.
Professor, thank you for joining us. Magandang hapon po sa inyo. Puntahan muna natin si Joseph Morong sa Senado. Joseph, ano bang inaasahan natin ngayon?
Na magtayap na ng mga loose ends yung prosecution ngayong araw, no? Kasi malaking interest talaga ng mga senador doon sa pinanggalingan noong mga umano'y bank records itong si Chief Justice Corona. Sabi ni Senate Presiding Officer Juan Ponce Enrile at lumabas sa kanyang pagtatanong kahapon na yung palang PS Bank ay nagbigay ng kopya ng mga bank records itong si Chief Justice Corona doon sa BSP, sa Bangko Sentral ng Pilipinas at sa AMLAC, no? At ang sabi ni Senate Presiding Officer Enrile ay mukhang malinaw na sa kanya na hindi galing sa PS Bank yung leak. Narito yung kanyang pahayag.
I am convinced na the leak did not come from the bank. They submitted it upon by virtue of respecting the authority of the Bangko Sentral and AMLA. Whether AMLA or the Bangko Sentral was the source of the leak is a conclusion that can be drawn from the questions that I asked. No?
Okay, Ivan, Cara, no, given that statement, hindi natin alam ngayon kung magiging interesado pa yung mga senador kung ipapatawag ulit itong si Quezon City Representative Jorge Bolet Banal. Ayon sa prosecution, depende raw yan sa kagustuhan ng mga senador. Kung halimbawa naman na hindi na, ay maaari na silang mag-proceed with Article 3. Finally, no? Ito yung tungkol sa flip-flopping umano at yung pakikipag-usap ni Chief Justice Corona sa ilang mga may kaso sa Korte Suprema, particular itong kay Lauro Visconde, no? At inaasahan ng prosecution na bukod dyan ay pwede na rin sila magpresenta ng mga ebidensya, mga testimonya galing sa PAL at saka kay Enriqueta Vidal ulit, yung Supreme Court Clerk of Court tungkol naman sa record ng kaso. Ivan, Cara.
Okay, Joseph, habang gumugulo ang impeachment trial dyan sa Senado, meron din nangyayari dun sa House of Representatives. May reaksyon na ba yung mga senador tungkol dun sa boto ng House Justice Committee na may probable cause para sampahan ng reklamong impeachment si Supreme Court Associate Justice Mariano del Castillo?
Tinanong na yan dati ni Senador Joker Arroyo, no? Sabi niya, tinanong niya, meron palang isa pang impeachment na nangyayari doon sa House of Representatives. I hope that the House does not become a parang cottage factory, cottage industry of impeachment, no? Nag-aalala rin sila. Pero ang sabi naman itong si Representative Neil Tupas, medyo matagal pa yung proseso for the impeachment itong si Del Castillo kasi dadaan pa siya ng plenary vote, no? Doon sa kabuuan ng House of Representatives. Hindi katulad itong kay Chief Justice Corona na they just needed 188 votes para maipasa na sa Senado. Yun, Cara.
Sa tingin ba nila makakaapekto ito sa nagaganap na impeachment trial ngayon, itong hakbang na ito ng House of Representatives?
Definitely, Cara, kasi hindi na malalaman ng mga senador kung paano nila hahatiin yung kanilang mga sarili. No? Kasi sa umaga, mayroong legislative work sila. Tapos sa hapon, ang schedule naman sa ditong impeachment itong kay Chief Justice Corona. So pag umakyat, halimbawa, itong impeachment dito kay Del Castillo, ay paano na yung schedule ng mga senador? May mga nababalam na rin daw na mga trabaho. Kahapon nga itong si Senador Jingo Estrada, nung tinanong natin tungkol dun sa schedule ng prosecution, sabi nila kasi they will finish yung case nila by March 23, ay sabi, sana, no? Kasi para makapagtrabaho na sila ng tungkol sa mga legislative work nila. So, definitely, it is a cause for concern for the senators. Pero we'll see kung makakaakit na talaga. Kasi dadaan pa naman yan sa voting.
And
if they can muster
the votes.
two-thirds of the vote. Yeah.
And pati rin syempre sa Kamara, di ba kahapon na Joseph, maraming mga kongresista ang nandiyan sa session hall ng Senado.
And if I may add, Cara, hindi sila nag-session kahapon.
Hindi sila nag-session kahapon.
Nag-open-close lang.
Kasi wala
dahil,
daw quorum.
doon yata sila nag-session sa Senado.
So, dalawang, Senado tsaka Kamara, kapag nagtuloy-tuloy itong impeachment complaint dito kay Associate Justice Mariano del Castillo, baka parehong houses
maparalyze na ang
na.
legislative work ng both houses.
Kahapon, di ba, nagreklamo na itong si Representative Lani Mercado Revilla. Sabi niya, parang open-close na lang nga yung ginagawa nila doon na hindi sila makapagtrabaho dahil they need quorum on certain aspects at hindi nila ma-achieve yun. Ngayon, tinanong na, kahapon naman yung mga congressmen kasi ay nandito para magbigay daw ng suporta dito kay Congressman Banal. Tinanong natin kung may mga congs ba dito na pinatawag or kung nagpatawag ulit itong si Speaker Belmonte na magpatawag ng mga congressman dito. Ang sabi naman ni Sunny, meron mga pangilan-ngilan na mga congressman pa rin dito.
Joseph, inaasahan pa bang sasala ngayon si Mr. Garcia o si Ms. Chongson ng PS Bank?
Meron pa kasi mga pinapasubmit na mga documents, particularly dito kay President kay Garcia III, yung ikalawang set noong specimen cards nitong si Chief Justice Corona. Although, ang sinasabi kahapon, mga sentiments is parang, okay, let's finish this na, parang pwede naman sigurong isubmit yan via a technical report na manggagaling sa PS Bank. So, we don't know kung ano yung magiging direction basically ng mga senators, kung sawa na rin ba sila dito sa Article 2. Pero mukhang interesado pa rin talaga kasi they really wanna find out. Kasi kung saan galing yung bank records, because this is a violation of our laws.
Ano ba yung sabi? Ano ba yung sabi ni Senate President Enrile? Bakit importante na pag-usapan kung saan nanggaling itong Annex A?
Bukod kasi sa violation siya ng ng mga laws natin, parang kasi yun yung basehan noong subpoena na inisyu ng Senado. Right. Parang ang lumalabas dito, nag-issue pala kami based on a quote-unquote fake na document, di ba? Na parang, ano to, parang nangyayari, parang, did you deceive us by not saying na this is false pala? Yun yung naging basehan namin ng subpoena. So, ang sinasabi ng defense is that it strikes at the very integrity of the Senate, and credibility na parang nag-i-issue pala kayo ng subpoena na hindi naman pala matibay ang basehan, Cara.
And having said that, si Congressman Banal kaya, sasalang pa?
Naka-standby lang daw siya, sabi nitong si Representative Sunny Angara, in case ipatawag ng mga senador. Kasi dapat kahapon, nagtaka rin kami na parang hindi siya sumalang. Pero during the trial, basically, si Senate Presiding Officer Enrile lang yung nagtanong. If you were able to watch it, talagang tinuntun niya yung pinanggalingan ng mga documents until he was able to reach yung point na nagbigay pala ng kopya itong PS Bank doon sa BSP AMLAC na nag-audit sa kanila ng September hanggang November 2010.
Okay. Maraming salamat. Joseph Morong, babalikan ka namin maya-maya lamang. At kanina nga po sa botong 3810, nakitaan ng House Justice Committee ng probable cause para isulong ang reklamong impeachment laban kay Supreme Court Justice Mariano del Castillo. Anong basa nyo rito? At given that ongoing pa ang impeachment trial ni Chief Justice Corona, kausapin natin ang ating legal expert ngayong hapon, Professor Avena.
Nakaka-apekto po ba ito? Kasi nag-warn na before si Senator Joker Arroyo na ayaw naman daw nila lumabas na parang cottage industry of impeachment complaints ang House of Representatives. And he's worried na kung magiging dalawa daw yung impeachment complaint. Makaka-apekto ba ito dun sa paglilitis ngayon with Chief Justice Corona?
Hindi dapat. Ganito yun may karapatan naman ang House under the Constitution na magdala ng impeachment proceedings kung may basehan sa tingin nila. At kung sumunod sila sa proseso, sasampayan sa plenaryo. Dahil ito House Committee pa lang naman, magdedebate pa yan sa plenaryo. Tapos magbobotohan pa sa plenaryo bago makarating ng Senado. So bilang nasa House pa, mayroon silang right to their own proceedings. Ngayon, kung ang tanong policy, as in, makakaganda ba yan o hindi, the Constitution allows as long as there is an impeachable officer at merong basihan, pwedeng ma-impeach siya. Nasa sa House yon. Ngayon, kung ang tanong ay hindi ba mahirap, makakagulo, quote-unquote, ito ang punto. Ang tingin ko dyan yung kay Justice Del Castillo, simple lang eh. Maliit na bagay lang.
Compared to what
yung nangyayari
yung articles of impeachment.
Pag sinabi
Isa
mo
lang
nating
ang ground.
simple, mas madaling patunayan, mas madaling i-prosecute, ganun po ba?
Yes, madaling proseso. It's just about the plagiarism issue, hindi ba?
Right.
So sa totoo lang, wala namang sinasabi na hindi totoo yung mga dokumento na kung saan merong plagiarism eh. Because it's a Supreme Court decision.
Yes.
So kinakailangan mag-stipulate na lang, di ba? In fact, judicial notice yun na may ganong talagang desisyon. Ang i-stipulate na lang siguro is, yun ba talagang hindi niya sinadya o hindi galing sa Microsoft? Yun ang sinabi niya, Microsoft glitch. Ang sinabi niyang Microsoft glitch, nasa proceedings yan ng Supreme Court. Again, pwedeng judicial notice yan o kaya dagdagan ng stipulation. No? Kung ano man ang gusto nilang patunayan, na halimbawa, yung kanyang assistant, hindi naman yata tumestigo yung assistant niya eh. Ewan ko, meron siyang sulat na explanation, ewan ko kung affidavit yan. Pero yung mga ganong klaseng ebidensya na gusto niyang ipasok para sa depensa niya, pwede i-stipulate na lang. So, napakasimple
At ito
bagay.
parang baka mas mapadali. One article lang ho siguro ito.
Yes.
If at all.
Yes, yes.
Pero pwede bang, ano yun, sabay nagugulong yung impeachment trial?
Yes, pwede yan.
Sabay silang dalawa?
Pwede yan, pwede yan.
Sa umaga yung isa, sa hapon yung isa, ganun.
Pwedeng namang isang oras lang bawat araw para doon kay Justice Del Castillo. Kasi napakasimple nga eh. Baka nga hindi tumagal ng 2 linggo yan eh.
May legal limitation daw po ba na dapat one impeachment trial o complaint per year lang? We're talking about the same officer, ano?
Oo, kung
Same
against the same
impeachable.
respondent.
Oo, pero kung dalawang
magkaiba
magkaiba,
to eh, oo.
Okay. Pero yun nga ho, ang siguro tanong ng taong bayan dito, hindi porket inaalaw kayo ng saligang batas na gawin nyo ito, gagawin nyo nga. Yun ho siguro yung pinupunto ni Senador Arroyo na parang wala na tayong nagawa, nag-impeach na lang tayo nag-impeach. Ano hong tingin nyo dito sa
yun
puntong ito?
Yun ang tanong ko eh. Ang tanong ko ay talaga bang walang nagawa? Mayroon naman eh. Kasi alam mo, kung susundan natin ang logic na yan, di para natin sinabi na napakarami namang murder sa rape cases na fina-file. Di ba? Napakarami namang corruption cases sa ombudsman, no? etc. Di, kontian na lang natin para hindi magulo. Hindi yata ganun. No? Kahit sabihin mo na impeachment ito, hindi madali ito. Pero kung simple lang, at malilimita naman, bakit hindi? Kasi karapatan ng House yan at ng taong bayan, di ba? Ayaw ng taong bayan ng mga unfit na public officials. Yun ang point doon eh.
At ang impeachment ang tanging paraan para matanggal sa pwesto.
Ng mga may immunity.
Yes.
Yung mga matataas na opisyal lang na nasa Constitution. Hindi naman lahat na-impeach eh.
Ma'am, sa ibang bagay naman po, pumunta naman tayo sa Senado ngayon kasi ito yung sa House. Ma'am, sa Senado po, kahapon, the whole day ng impeachment, ang tinake up lang nila ay kung saan nanggaling itong supposed leak or yung Annex A na sinasabi. Bakit po ba importante na malaman pa natin kung saan nanggaling itong Annex A na to? I understand, hindi naman po ebidensya itong Annex A, di ba? It was just used to subpoena the bank records na inadmit na yun yung evidence, yung bank records. So, bakit po ba importante na matuntun kung ito ba'y nanggaling sa AMLAC o ito ba'y nanggaling sa PS Bank?
Ang totoo niyan, mulat sa pulha, ang sinasabi ko na ay hindi talaga yan relevant doon sa merito ng impeachment trial. Dahil sa impeachment trial, ang tinitingnan naman is yung, if you remember, ang unang tiningnan yung SALN.
Yes.
Pangalawa, yung mga propiedad na mukhang lumalabas house and lot saka condo unit. Pangatlo, yung income ng Chief Justice na pinapakita through ITR.
ITR, yeah.
ITR, income tax return. Ika-apat, yan yung bank records. Yan yung ika-apat. So, noong pinapakita ng prosecution, kung sana, maipakita na meron ba siyang mga bank account na hindi sinabi sa ALN. Yun pa rin yun eh. Ang tanong pa rin meron ka bang propiedad at kasama dyan ang bank account na hindi sinabi sa SALN? Yun ang tanong eh. So, kung yun lang ang titingnan, meron ba o wala? Yun ang merito. Pero pag lumabas ka na dyan at yung tinatalakay nga is, saan ba galing yan, ginawa mong basihan ng subpoena, hindi na diretso sa merito, kung hindi sa procedure na lamang. So, ang tinatanong natin, bakit pinagtutuunan ng atensyon? If you ask me, maraming motibo dyan na pwede. Pero tingnan na lang natin yung epekto. Okay. Unang-una, dahil sa pagtuon ng atensyon na yan na mahigit na 1 linggo, ano ang epekto? Delay. Di ba? Hindi makaka-graduate sa Article 2 na para pumuntang Article 3. Number 2, hindi sa nagsasabi tayo na sinasadya ito o kung meron mang mali siya. All we're saying is may epekto na nako-confuse ang tao. Correct? Nalilito tuloy ang tao. Ang sabi ko nga, imbis na eyes on the ball, napupunta sa ibang parte ng gallery. No? Oo. Alam to ni... Yes.
Ipagpapatuloy po natin ang ating talakayan maya-maya lamang. Simula na ho ang ating impeachment trial. Dumako na po tayo sa Senado.
Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Legarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, Senate President Enrile.
With 18 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 20, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 20, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. Majority Floor, the
Call the case,
Secretary will please call the case before the Senate sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato Corona.
Appearances, Majority Floor Leader.
Yes, the prosecution, Mr. President.
Good afternoon, Mr. President, and the honorable members of the Senate sitting in impeachment. Same appearances for the prosecution,
Noted.
Your Honor.
The defense.
Your Honor, please. The same appearance for the defense, Your Honor.
Noted.
Thank you. Mr. President.
Majority Floor Leader.
Yes, Mr. President, may we recognize Senator Miriam Defensor Santiago
The
for
lady
the business for today.
senator from Iloilo.
Both counsel, please take your seats.
Thank you, ma'am.
Mr. President, first, I humbly beg the indulgence of our colleagues. Particularly, I apologize very profusely that I always take the floor at the beginning of the impeachment trial. The reason is medical. After 2 months, it is only now that my blood pressure has become normal. But I'm now suffering from chronic fatigue. If you remember, a couple of years ago, I took prolonged sick leave because of chronic fatigue. This period's chronic fatigue might be caused by the fact that I'm suffering from what is called in layman's terms, lazy bone marrow. That is to say, my bone marrow apparently does not manufacture enough red blood cells, and I have to be injected every week to get my blood cells to normal. That is the reason why I cannot stay long. That is why sometimes when I'm speaking, I sound like I'm out of breath. Also, not only am I hyperventilating, I have palpitations when I am in trial court. Now to go to the business of the day. Some observers of our proceedings might wonder why we have spent time determining whether the specimen signature card submitted by the prosecution with the qualification that they do not vouch for its authenticity. Some might wonder why we are spending time on whether these specimen cards are true or false. The answer lies in this basic rule of evidence that is expressed in Latin as follows: falsus in unum, falsus in omnibus. This is a very serious and basic principle in evidence. Once the court is convinced that one panel has been foisting a fake document on the court will be then justified in indulging the disputable presumption that if one panel has been lying on one particular, then he has been lying on all particulars and will have to disbelieve everything that that panel offers in evidence. That is the scope and meaning of falsus in unum, falsus in omnibus. Lying in one particular, lying in all particulars. That's why, as a senator judge, I would like to counsel prosecution, be extremely, extremely careful, gentlemen of the prosecution, because you might be treading on very thin ice. Falsus in unum, falsus in omnibus. There was a theory expressed in this court that actually the attachments to the request for subpoena prosecution are not fake or are not forgeries because they are simply, as the bank official testified, they are simply inconsistencies or discrepancies, which the bank official said, according to their count number, over 40 inconsistencies or discrepancies. Thus, we have to turn to our penal code to determine whether the specimen signature cards, both from the bank and from those submitted by the prosecution, constitute falsification. Under the Penal Code Article 171, as related to Article 172, falsification is, by among other methods, committed by, quote, making any alteration or intercalation. Intercalation means insertion in a genuine document which changes its meaning. And by the way, there is a difference between the term forgery and the term falsification. Under the Penal Code, the term forgery is usually applied to banknotes. For example, if you print Philippine pesos or US dollars, then you're guilty of forgery if you are passing off these counterfeit notes as genuine. But if you are falsifying a commercial paper, like a specimen credit card of a bank, that is the crime of falsification. And it is a crime to knowingly introduce in evidence in any judicial proceeding such a falsification. I have a whole list of cases that I looked up when I left the session hall yesterday, but I will just quote a 2010 case because, as you know, in law, the later the decision, the more authoritative it becomes. Ramos v. People, 2010. The elements of falsification of commercial documents are, number one, that there be an alteration or a change or intercalation or insertion on a document, that it was made on a genuine document, that the alteration or intercalation has changed the meaning of the document, and that the change made the document speak something false. That's the Supreme Court speaking on what is a falsified document. Now, maybe some of us might think that we should call for a handwriting expert, but that is not the jurisprudence. We don't need a handwriting expert because jurisprudence tells us that mostly courts disregard what a handwriting expert says, and it's up to the judge to determine for himself visually whether what he is seeing before him are, as described by the Penal Code, changes or insertions that tend to give a different meaning to the document. So the importance of this topic in our impeachment proceedings might overshadow the need to hurry and finish the impeachment trial, because if we can prove, if there is proof on record that the signature specimen cards were falsified as falsification is defined under the Penal Code, then perhaps the court might lean towards considering the maxim falsus in unum, falsus in omnibus. It is not relevant to say, anyway, the people responsible will have to be accused in a criminal case, and so you have to find somebody who will file an accusation against them. That is completely irrelevant. The question before the impeachment court is, does this Latin maxim, false in one particular, false in all particulars, apply to the instant specimen cards? Thank you.
Thank you. Majority Floor Leader. What's the pleasure of the counsel for the defense?
Thank you, Your Honor. Your Honor, please, before we start today's proceedings, may I be allowed to make a short manifestation, Your Honor?
Proceed, you have 2 minutes.
I would like to appeal, Your Honor, to this honorable body for a re-examination, Your Honor, of Rule 17, Your Honor, of the Impeachment Court, Your Honor. The rule reads as follows. If a senator wishes to put a question to a witness, he or she shall do so within 2 minutes. A senator may likewise put a question to a prosecutor or counsel. He or she may also offer a motion or order in writing which shall be submitted to the presiding officer. We are pleading for an examination of this rule, Your Honor, to avoid the usual occurrence of what is known as mistrial, Your Honor. Because while it is true that the proceedings of this court as of the moment may not amount to a mistrial, it is equally discernible that it may be raised in the future in the event that the situation goes worse than this. And the reason for this, Your Honor, is counsel, whether private or defense counsel, is precluded from raising an objection or arguing with a member senator, Your Honor. This is not the same rule that we have before, because in the old rule, Your Honor, there is that opportunity for counsel representing an impeached public officer to object to any question raised by the Senate member, Your Honor. And if the objection is raised, the court is under legal obligation to examine the same and deal with its merits. In other words, it is ruled upon whether by the presiding officer whether it should be allowed or not, Your Honor. Now we say that this may amount to a mistrial, Your Honor, because there is nothing left in favor of an impeachable public officer or an impeached public officer. He cannot object, he cannot make any manifestation, and in all probability, as what we have noticed before, the question of a member of this court centers on practically everything, Your Honor. One question may be raised, followed up by another, leading to a request for the issuance of an order requiring the production of certain documents, which document had not yet been proved to be material to the issue or relevant to the subject matter under discussion. Under such a situation, Your Honor, notwithstanding the fact that a counsel or the defense counsel in this particular instance moved for a denial of the motion, still the order is granted, a subpoena is issued, and notwithstanding the fact that a motion for the dissolution or quashing of the subpoena is made, it may likewise be overruled. Under such a situation, we have no other recourse before this honorable court, Your Honor, and probably the only recourse is to go to the Supreme Court of the Republic of the Philippines. Now, that will be rather not only burdensome, but almost a nullity as a remedy, because it will take time before preparing the necessary pleadings, before the same is scheduled before the appellate court, and before any action can be made on the matter. In other words, we may come into a situation where the Tagalog, anim pa ang kabayo, anim pa ang damo kung patay na ang kabayo. If the remedy may be granted later, but the proceedings went on, and there is that violation of the constitutional rights of an accused, we submit, Your Honor, that these are reasons enough to warrant our plea for a re-examination of this particular provision, Your Honor, not to favor the defense, much less the prosecution, Your Honor, but so justice may be done, Your Honor, and to avoid what is known in law as a mistrial, which may ultimately result in the nullification of all the proceedings that were held under the old rule, Your Honor. We believe that this is not only asking justice for the defense, but likewise for the prosecution, because the question of the member senator, Your Honor, may be favoring the defense. Not all the time the prosecution, or it may be favoring the prosecution. And since there is no definite category of what may be asked, whether in the form of merely clarificatory question or cross-examination question, there is where we feel that the apprehension becomes greater, because ultimately the respondent public official may be railroaded to a verdict of guilt, Your Honor. Hence, it is again our plea, Your Honor, that this rule be the subject of another judicious examination in order to determine whether there is really a room for improvement, just so justice may be meted out in favor of everybody. Thank you very much, Your Honor.
The Chair would like to find out clarificatory questions from members of the court is not objectionable by either side.
Yes,
To clarify facts, to clarify, to obtain information that is vague or rather not understandable by any member of the court.
we submit that they are not objectionable, Your Honor.
Okay.
But first and foremost, may we be enlightened as to why the right to object against any examination question by a member of this court is now prohibited or prescribed under the new rule, Your Honor.
Well, that is the rule adopted by this court, and frankly, I'm not privy to the adoption of this rule. I do not know when it was adopted, but anyway,
When we were,
it was adopted, I think, during the preparation of the impeachment trial for the former ombudsman.
when we were examining towards the root of this change, Your Honor, we found out that the right to object has been granted to counsel and or his impeached client, Your Honor. We would like...
This was during the time of the trial of the former president
Estrada, that's correct, Your
Estrada.
Honor. And since then, there was no impeachment proceedings that had taken place sufficient enough to show any flaw, any evil, or any wrong attendant to such a ruling. We were surprised, Your Honor, why that particular portion of the old rule had been totally obliterated and taken off the present rule now.
Well,
Because
Your
it
Honor,
may not... our position is that
let the counsel for the defense.
yes, I thought it was done.
All right.
our point, Your Honor, is to make the rule more in accord with the constitutional requirement of on the matter, especially the Bill of Rights, which grant to every person the right to life, liberty, and property. He cannot be deprived of any of these things in violation of the due process clause.
Yes.
It is our humble submission, Your Honor, that with the old rule, there is greater attachment, there is greater adherence to the observance of the protection of the right to due process, Your Honor.
We are conscious of that, Mr. Counsel, and I cannot rule on this at this moment. This has to be taken up by the court in a caucus, as we have practiced in order to arrive at a reasonable resolution of the issue you have raised. But I can assure you that as much as possible, we will try to accord the respondent a fair trial, observing not only substantive but procedural due process, in order to not to intrude or rather derogate anything from the application of applicable provisions of the Bill of Rights. Now, may I ask a question from a member of the court to test the credibility of a witness presented by either side? Would that be acceptable to both sides?
Acceptable to the prosecution, Your Honor.
How about the defense?
With more reason, Your Honor, if the purpose is to test the credibility of the witness on the stand who is under examination, we can interpose no valid objection, Your Honor.
Yeah. And,
We are in total conformity and in full accord with that suggestion, Your Honor.
And for instance, the presiding officer extensively questioned two witnesses for the prosecution yesterday, precisely because of the fact that the issue involved an attachment to the request for a supplemental subpoena duces tecum to produce a document desired from a bank, covered by certain laws that in turn covers the document with a certain amount of confidentiality. So I do not know whether that is objectionable to the defense.
To us, Your Honor, we could interpose no valid objection to such a procedure, Your Honor. But if the questioning by way of testing the credibility of the witness will amount to, let's say, discovery again of certain documents, and then he is ordered to produce without the benefit of a subpoena, Your Honor, that is worse than a subpoena itself, because a subpoena duces tecum may be quashed, may be objected to, but if there is a motion on the part of the member of this court requiring a particular witness on the stand to produce document, automatically is under legal obligation by direction of this honorable court, Your Honor. We are not saying that it is not valid. We are not saying that it is illegal, Your Honor, but it borders on what is known as gray area, whereby the right of a party on the stand may be prejudiced, and also the party under trial, Your Honor.
Well, we'll take note of your
we are not
manifestation.
Before we end, Your Honor, it is not our purpose to have a drastic action on our plea, Your Honor. We are pleading this matter to be brought to the attention of this honorable court only for purposes of examination and judicious evaluation. With that, Your Honor, we thank heavily this honorable court, Your Honor.
May we make also a manifestation, Mr. President?
Just a minute. The presiding officer is conscious of the rights of the respondent and the role of the prosecution as well as the defense in this case. And I can assure you that I've been following that norm. But we will take this up in caucus.
Thank you, Your Honor.
The chief of the panel of prosecutors from the House.
Yes, Mr. President, may we just make a counter-manifestation on the matter? There's a saying in English which says that if ain't broke, don't fix it. Kung wala naman diferensya o sira, huwag mo nang kukumpunihin. The rules as they stand now are perfect, Mr. President, because by presidents, we have been doing this in the 11th Congress in the hearing of the case, in the impeachment case of President Estrada, these same rules applied. And even in the U.S. Senate, Mr. President, this same rule is found in the rules of the U.S. Senate, that senators sitting in impeachment can ask questions from witnesses and from counsels. The only difference is that in the U.S. Senate, the questions are written and submitted to the President, Mr. President. But they are certainly allowed to ask questions. And on the part of the House, we have been maintaining, Mr. President, that an impeachment case is an administrative case, where the only issue is whether the public officer still enjoys public trust in order that he can still continue to hold office.
If I remember what I read correctly, counsel, in the case of in case of impeachment, the role of the House of Representatives is that of a grand jury. You are supposed to have prepared the evidence beforehand. In fact, your powers to gather the evidence beforehand is plenary. It's in fact inquisitorial in nature. And that is why we have a problem in the course of this trial, because we are using compulsory process to gather evidence for you.
Yes.
That you should have gathered beforehand before you filed the impeachment, articles of impeachment in this court. And that's why I warned you several times that what you're doing might be fatal to the proceedings. You read American precedents in impeachment cases. The function of the House is like that of a grand jury. I have it researched. And in a grand jury proceedings, it is almost an inquisition. There's no adversarial proceeding. You can subpoena any record from any sector, but you are called upon to keep these subpoenaed records absolutely confidential, not exposed to the public as what is being done in this proceeding. You should have read those materials before you instituted these articles of impeachment. But anyway, we are already at this point. It's too late to backtrack, but it's a lesson that we have to learn.
Just 1 minute, Mr. President, on this matter.
Before that, Mr. President.
No, I suggest that let the chief of the prosecution panel.
I submit, Mr. President.
Thank you, Mr. President. There are three modes of initiating impeachment complaint, Mr. President. If indeed it passes through the Committee on Justice, then we could have been afforded all this time to exercise the powers akin to a grand jury. But, Mr. President, there is a third mode which is specifically granted by the Constitution, where in case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, it shall be sent immediately to the Senate because, Mr. President, yung impeachment po kasi emergency power po ito ng mamamayan. Halimbawa po, kung yung Pangulo ng Bansa o yung punong maestrado po sa tingin ng isa bawat 3 miyembro ng Kamara po ay talagang dapat panagutin kaagad-agad, hindi na po dadaan doon sa grand jury style, kundi idudulog na po kaagad dito at maglilitis na po kaagad tayo dito dahil kung emergency nga po, baka masira po lalo yung opisina kung dadaan po doon sa proseso.
Tama po yun, pero ibig ba ninyong sabihin na kahit na 1/3 ng House of Representatives ang pumirma, ay pupulutin ninyo sa hangin yung ilalagay ninyo sa articles of impeachment na wala kayong batayan?
Di naman po, dahil katulad nga po nito, meron naman po silang ginawang mga artikulo of impeachment na may mga nakalahad naman po doon kung ano yung mga reklamo at nahimay-himay po naman.
Alam mo, kaya magulo yung inyong articles of impeachment. Kaya nga nahihirapan kami na kung saan namin papasyahan yung mga ebidensya na ipinapasok ninyo. Kaya na sa Article 2 lamang, nagkaroon tayo na ng problema. Pagdating natin sa Article 4, Article 5, Article 7, Article 6, Article 7, halo-halo yung aligasyon ninyo. Eh, pag binuksan ninyo yan, makikita natin ang kamalian eh. Oh. Anyway, we proceed.
Yes, Mr.
And
President.
we take advisement on this matter.
Mr. President.
Thank you, Mr. President.
Mr. President, as the chairman of the Committee on Rules, first I would like to thank the prosecution for saying that the rules are perfect. But nevertheless, the prohibition to object is not found in the rules of the Senate, indeed, but it is found in the practice in courts, wherein you cannot object to the question of a judge. But be that as it may we recognize Senator Angara and then Senator Joker Arroyo, yes. Mr. President, so that they may amplify this position of the Rules Committee.
The issue is very simple, Mr. President. The question being raised is that why is it that the defense or the counsel of either side cannot object to a question by a senator judge? The majority leader is correct. There is no ban, there is no prohibition against any of the senators, any of the lawyers objecting to a question. But it's in the form of objection that there is a difference. You perhaps may not say, I object, Mr. Judge, but you may say, Mr. Judge, I file a reservation or an exception to that question because it tends to prejudice my client. But I think for the sake of fairness and even the perception of fairness, I think we ought to really allow any of the lawyers to make an exception rather than object verbally to a question of the judge. Because even in a grand jury, that is the procedure. In a grand jury, it's a free-for-all. You can ask almost anything under the sun without leading question, even misleading question. But the lawyers can stand up and say, we make an exception to that, so that you preserve your right to question it on appeal. Now, if what I think the good distinguished jurist is intimating and suggesting is that it will become a reversible error for mistrial, I think that's even worse, because I think we ought not to think at this stage of a mistrial, because of a procedure that will allow an appeal on every perceived reversible error, because it will prolong the political agony of this nation. If every issue, every issue that one thinks is irreversible can be questioned on appeal. So we also appeal to the lawyers in the same spirit that our presiding president said. Let us go straight to the point. Wala nang paliko-liko sapagkat naghihintay ang bansa. Thank you, Mr. President.
Maraming salamat po, Ginoong Hukom. May I just, only 1 minute, Your Honor. There is a statement, with the kind permission of the Honorable Court, there is a statement on the part of the Honorable Counsel for the prosecution, Your Honor, that in the Estrada impeachment trial, the right to object cannot also be made. That is precisely why we brought this matter to the attention of this Honorable Court, because in that proceedings against the Honorable President Erap Estrada, the right to object is found, and it was only deleted under the new rules now. We wanted to know, and we are appealing to the impeachment court to merely have a re-examination. We are not imposing our will. We are appealing to the understanding and judicious management ability of this court, Your Honor, to render more justice in consonance with the right of the accused against due process, Your Honor.
We cannot amend the rules now, because to amend it will delay the proceedings. We'll have to republish it, publish the rules. But we will take this up in caucus and consider your suggestion in the light of the suggestion of a member of this court, Senator Angara.
Thank you, Your Honor.
All right, counsel for the prosecution, do you want to make any statement?
Well, Your Honor, with respect to the reference of my statement, what we said was the matter of judges asking questions to counsel and witnesses. But as to their objecting, I did not make any statement as to whether counsels can object to questions of.
Yeah, precisely. It is actually the substance of the statement of the defense counsel, if I understood it correctly, is the tendency of questions being asked as if it is in favor of one or the other party. So I think that we will have to take up in caucus.
Thank you, Mr. President.
The gentleman from Makati and Bicol was raising his hand.
Mr. President, he has withdrawn. And just concurred with what Senator Angara and the Majority Floor Leader manifested, Mr. President.
All right. What is the stage of the proceeding now?
We are ready for the business for the day. We're supposed to receive documents from the PS Bank President, requested by a number of members of the Senate, an inventory of documents from the PS Bank related to the bank account of respondent, CJ Corona, which were submitted, shown and examined by the audit team of Bangko Sentral, MDA-MLC. the names of specific officials of Bangko Sentral and AMLC who participated in the audit and handled the bank records of the Katipunan branch and the bank account of respondent CJ Corona. Also request by Senator Estrada for the logbook of the access, and then request of Senator Legarda to provide a technical description of their document as opposed to the annexes submitted by the prosecution, and a request of Senator Pimentel for the submission of any other available customer identification and specimen signature card in the name of Corona, Renato Coronado. Aside from that, after that, we have already discharged the witness, Mr. President. We will just await this for the submission of these documents, and then we will be ready for the BPI representative.
We will give the officials of the bank concerned how many days to comply with our request. This is not an evidence for the prosecution or for anybody. It is these are documents required by the court to evaluate the supplemental request for a subpoena ducis tecum, where a document is questioned as a proper document for that purpose. And this is addressed entirely to the attention and discretion of the court. So ordered.
Mr. President, may we make a manifestation regarding... Yesterday we were directed by this Honorable Senate to submit a memorandum regarding the nature of the testimony of the bank officials.
Not the nature of the testimony of the bank official with respect to a document that he presented to be marked and requested by your panel to be marked as your exhibit. Although the witness was questioned by the defense as no longer whether he is your witness or not witness. And there was no, when the chair asked the member of your panel to state for the record whether you are adopting the witness as your witness, I think his answer was that you just wanted the document to be marked as an exhibit for the prosecution.
That is the manifestation we're going to make, Mr. President, because I was instructed by our lead prosecutor that after conference last night, the panel has decided that we will adopt the witness as our own with respect to the evidence, the documents that he presented yesterday as to 8 accounts, Mr. President.
All right.
And that they will be marked as evidence for the prosecution.
Whatever that witness stated yesterday, you are bound by his statements.
Yes, Your Honor, Mr. President.
All the declarations, statements, admissions made by her and by him. Which one of the witnesses that were presented yesterday would you adopt as your witness?
The President, who submitted the certifications as to 8 other bank accounts, Mr. President.
And how about the statement of the bank manager?
I've been instructed that it's only with respect to the President as far as the documents that they presented.
Only the statement of the President of the bank and the documents that he used as a part of his testimony.
Yes, Mr. President, respecting 8 bank accounts of the respondent, Mr.
Counsel,
President.
for the defense.
If Your Honor, please, this is one of the pitfalls that I notice in our process of trial, Your Honor, because the witness on the stand was under direct examination of the Honorable Presiding Officer and the member, senators of this court, Your Honor. Now, if this witness is now being adopted on the basis of what had been on the questions whether direct or cross, Your Honor, which had been propounded or made by any member of this court, and most especially the presiding officer, Your Honor, then they are relieved of the burden of undergoing introduction through direct examination, Your Honor.
To shorten this, would you object to the adoption by the prosecution of the bank president as their witness only in relation to the document that they wanted to mark?
We are constrained to object, Your Honor. We are sorry that we cannot accommodate the prosecution on grounds of due process, Your Honor. The witness had not been examined by them. The examination was done by a member of this court and the Honorable Presiding Judge, Your Honor.
That is true. That's why
we can. I'm sorry, Your Honor.
That is true. That's why yesterday I directed your private counsel, member of your panel, whether he was adopting the witness as his witness with respect to that document. But the witness was not his witness anymore because you finished your direct and redirect examination of that witness. He was discharged. And yet he said that he had an authority to back up his statement that they can mark the document coming from that witness who was presented for examination by a member of this court. So, did you have a backup jurisprudence on this claim?
I was told by them that they were willing to and ready to submit a memorandum, Mr. President, but after due deliberation and conference, they decided that to abbreviate the proceedings, we will just adopt the witness as far as...
You have to show us the propriety of doing what you want to be done.
Yes, Mr. President. We will
because, I cannot remember in any of my trials that could be done after you discharge your witness.
We will submit, Mr. President.
So ordered.
Okay, Mr. President, we are now ready for the continuation of the presentation of evidence by the prosecution.
Mr. President, may we call on the representative of BPI who is appearing here in lieu of Mrs. Dizon who gave birth, Mr. President.
All right. This is your witness, huh?
Yes, Mr. President.
What's the purpose of this witness?
May I call on the private prosecutor who will handle the direct examination of the witness to make the offer, Mr. President.
With the kind permission of the Honorable
Attorney Arthur Lim, Mr. President.
There was similar manifestation made yesterday, Your Honor, and the Honorable Presiding Judge ruled that what we need is Mrs. Dizon and not a substitute of Mrs. Dizon, because I believe that the questions that will be propounded to her will be personal in character. That was the ruling of the Honorable...
Personal knowledge of Mrs. Dizon.
Yes, Your Honor, exclusively within the knowledge of Mrs. Dizon.
That's correct.
May we make a manifestation, Your Honor?
What is your manifestation?
We respectfully disagree with the defense counsel because our understanding is that the witness who will testify today, who is the authorized representative of BPI Ayala branch, will be merely identifying documents that were required by the Honorable Impeachment Court. It is not to testify on a matter based on personal knowledge. Specifically, Your Honor, the documents in issue or to be brought and produced now are the monthly bank statements, which the Honorable Presiding Officer specifically directed the bank to produce.
All right. Your request is granted.
Thank you, Your Honor. May we call on
you call the witness.
Please stand, Madam Witness. Do you swear to tell the truth and nothing but the truth in these impeachment proceedings?
Yes, I do.
So help you God.
May I proceed, Your Honor?
Proceed.
Will you kindly state your name, address, and occupation, ma'am.
I am Mara Davak Arcilia, 31 years old, married, with office address at BPI Ayala Avenue SGB branch in Ayala Avenue, Makati City. I am the assistant branch manager of BPI Ayala Avenue SGB branch.
Your Honor, please, for record, in relation to the recall of this witness by the Honorable Court.
Has he testified before? Why are
Not recall, Your Honor.
Why are you saying recall this witness?
Of a BPI officer, Your Honor. It was supposed to be the branch manager. I withdraw that, Your Honor.
Be careful with your statements here.
Yes, Your Honor. In connection with the testimony of the witness now,
Wait a minute. Are you presenting this witness for the first time?
Yes, Your Honor, as a BPI representative.
All right. Then don't say that he is being recalled to the witness stand.
I'm sorry for that, Your Honor.
Yeah. Now, place her under oath. Has she been placed under oath? All right. Proceed to ask the question.
Yes, Your Honor, but we are just indicating that we are respectfully offering the testimony of this witness to prove the monthly balances of the various BPI accounts of the respondent.
To prove the monthly balances, then prove that she has knowledge about those monthly balances.
Yes, Your Honor.
Qualify her.
Yes, Your Honor.
All right.
Will you tell the Honorable Court your position in the bank again?
I am the assistant branch manager of BPI Ayala Avenue SGB branch, sir.
Will you state your duties and responsibilities?
My main function in the branch is cashiering.
Why are you before the Honorable Court today?
Sir, I was asked to bring and to submit the documents requested by this Honorable Court from Ms. Dizon.
For Ms. Dizon?
For Ms. Dizon, yes, Your Honor.
Why for Ms. Dizon? If you are qualified to testify, why are you using the term for Ms. Dizon? Counsel, qualify your witness.
Yes, Your Honor. Will you explain to the Honorable Court where Mrs. Dizon is right now?
That is not the way to qualify the witness. What is your job in the bank?
I already asked that, Your Honor.
All right. What is her job?
I'm the assistant branch manager of the branch. And
do you have anything to do with the preparation of monthly bank balances?
None, Your Honor.
Oh, how can she be competent?
Your Honor, can I make a manifestation?
I'm asking you, how can your witness be competent?
She is here to produce merely documents, Your Honor, of the bank.
Then don't say that she is going to prove the bank balances because she's incompetent.
Your Honor, please, the documents required by the Honorable Court.
Just ask her about the document. If she knows that document, identify the document. Don't tell this court that you're proving the bank balances because she's incompetent. She has nothing to do with the preparation of the bank balances.
We submit, Your Honor. May I proceed, Your Honor? Did you bring the documents required by the Honorable Court and which Mrs. Dizon requested you to bring here?
No basis, Your Honor. The question, if we may be allowed to explain, Your Honor, the question asked for the authority to bring the document. There is no showing that a subpoena had been issued delineating the particular documents, book, or accounts that must be produced by the witness in today's hearing, Your Honor. In the first place, no subpoena had been mentioned by the witness.
Your Honor, please,
have you requested for a subpoena?
It was a direct order of the presiding officer.
No, the order of the presiding officer, you might think that I'm senile. I'm 88 years old. But I remember what I say in this court. Was for the two panels to go to the bank to examine the bank balances. But the other side does not want. So you have to proceed with the proper request.
Your Honor, please, the witness is here because of an order of the Honorable Presiding Officer by reason of a request of a Senator Judge for these documents to be brought here, Your Honor.
If may be, there can be no truth in that because
just a minute.
The witness.
Mr. President, the records will bear us out. Attorney Cuevas cross-examined the previous witness on the monthly accounts, on the monthly statement of accounts. And then he said that this monthly statement of accounts should be produced before this court. The court made an open order for the documents to be produced and the documents to be brought before this court. Thereafter, for his own reasons, Attorney Cuevas withdrew his request. But the court has already issued an order in open court, direct order to the witness to produce these monthly reports, a monthly statement of accounts from 2005 to 2010. And that was the order of the court. And
may I request the stenographer of the court to locate the order of the presiding officer? Yes. I'm sorry that I cannot remember all the details.
Can we then ask for a 1-minute suspension while this is being...
Yes. So, trial suspended for 1 minute.
Pansamantala pong nagsuspende ang impeachment trial habang inuungkat pa yung kung ano ba talaga napag-usapan tungkol sa pagpapatawag ng mga dokumento mula dito sa BPI Ayala Avenue.
Matatandaan natin, Ivan, nag-testify dati yung branch manager ng BPI.
Si Ms. Dizon.
Tapos tinanong siya nitong si Defense Counsel Cuevas na kung pwede bang ipakita rin yung monthly para hindi nga makita kasi gusto nilang i-prove na hindi isang bagsakan yung mga pera na nandoon.
Anyway, pag-usapan po natin yung nabanggit kanina sa pagsimula pa lang ng pagdinig. Itong si Justice Cuevas, may...
Binanggit niya yung mistrial.
May reklamo siya Anong tingin niyo dito? Nabanggit nga ho niya yung salitang mistrial dahil parang nauubusan na raw ho ng remedy ang akusado dito sa kasong ito dahil pag nagtanong daw yung mga senator judge, hindi pwede mag-object, hindi pwede mag-manifest, hindi pwede. Paano ho ba dapat?
At ang hinihingi nila, ma'am, ay payagan ang prosecution or ang defense na mag-object sa mga questions ng senator judges. Do you think this is...
Kasi nasa rules na ginawa ng Senate body na bawal mag-object ang mga partido sa mga tanong ng senator judge, whether it's part of the 2-minute rule or not, no? Ang intindi ko dyan, yung mga senador kasi gusto nilang mag-clarify. There are times na gusto mag-clarify. At kahit sa ordinaryong kaso, whether criminal or civil, yung hukuman may ganoong karapatan din. At ang dahilan ay dahil ang huwes ang magdedesisyon, gusto niya maintindihan kung ano bang pinag-uusapan. So, merong mga panahon na yung testigo hindi malinaw magsalita o kaya medyo vague yung ibig sabihin, tatanungin ng hukuman. So, ganyan din itong mga senator judges. Kaya gumawa sila ng rule na pwede sila magtanong. Ngayon, bilang mga gustong malaman kung ano ba talaga ang nangyayari, gustong magklaro ang mga judge, sinasabi nila na yung partido, huwag ka na mag-object dahil ang presumption, syempre, yung huwes, alam niya ang tinatanong niya. Matalino siya, kaya nga siya huwes. No? At may karapatan siyang maintindihan dahil siya magdedesisyon Okay. Yung mga objection kasi ng partido, nakatuon yan sa kabilang partido dahil natural adversarial silang dalawa No, kumbaga nag-iisahan sila in a way, 'di ba? Parang yung isa pipigilan yung kabila, 'di ba? So, parang ang punta ng huwes bakit mo sa akin itutuon ang objection na 'yan? Samantalang gusto ko ngang mailinawan. You cannot presume na ang dahilan ng pagtatanong ko may motibong masama, no? Kundi gusto ko magklaro.
Pero ang sinasabi po ni Justice Cuevas, meron daw po kasing mga ebidensya na lumalabas out of yung pagtatanong ng senator judge na dapat clarificatory lang, di ba? Hindi dapat yung senator judge ang nagpapalabas ng...
At sila yung nag-uutos na magdala ng dokumento sa korte.
Right. Yung punto na yan, makikita natin ay pumapasok ngayon. We are midstream. Kumbaga, nasa gitna ng ilog. No? So itong punto ni Attorney Cuevas, mas maganda sana kung noon pa niya sinabi, dahil to change rules in the middle of the game will also be messy. Talagang makakalito naman at makakaantala kung ngayon pa papalitan ang rules. Kasi panibagong debate yan.
Itutuloy po natin ang ating talakayan. Professor, balikan po natin ang impeachment proceedings.
Statements over the period from the time the bank, this checking account was opened up to the year ending December 31, 2010. So this witness cannot be presented as a witness for the prosecution because the request was made by a judge of this court, and the request of the senator judge from Iloilo was approved and ordered to be obeyed by the bank. Yes.
Mr. President, may I also respectfully refer the Honorable Senate President to page 62 of that transcript of the journal, Your Honor.
Yes.
Okay, on top of the page 62, if I may read.
Yeah.
Mr. Cuevas, quote Mr. Cuevas, in view of the answer of the witness, Your Honor, may we respectfully request that the statement of account covering these periods 2005, 2006, 2007, 2008, 2009, 2010 be produced by the witness at the most convenient time, considering her condition now, Your Honor. And then several lines below that, the presiding officer, quote the presiding officer, all right, so the witness is instructed by this court or ordered by this court to produce the documents that the defense counsel requested. So,
what line is that?
On page 62, on top of page 62, and the line that I just read, sir, is 1, 2, 3, 4, 5, 6, 7, 8, 9. About 10 lines from the bottom, sir.
Yes. So the witness is instructed by this court or ordered by this court to produce the documents that the defense counsel requested. So this witness is not a witness for the prosecution, but simply required by this court upon a request by a senator judge of this court to produce the document.
So, yes, maybe to cut short the proceedings, Mr. President, if she can produce the document, this will cut short all the discussion.
Precisely.
Yes.
Precisely.
So, if the witness can now produce this document, Your Honor.
Now, Madam Witness, you're here upon order of this court to produce the documents that it required to be produced by Ms. Dison. Do you have those documents?
Yes, Your Honor.
All right, present them to the clerk of court.
If Your Honor, please.
Yes.
I hope the court pardons us. May we note the concept of this examination question, Your Honor? Because I'm through with the proceedings. I'm sorry, Your Honor.
Yeah, just a minute, counsel. If you remember, there was a, if I recall correctly, in one hearing day, we tackled this issue, and the presiding officer suggested that both counsel will go to the bank to examine the monthly statements for the years involved up to 2010. I think it was from 2005 to 2010. Later on, the defense counsel said that his client has these monthly bank statements. Isn't it?
Yes, Your Honor. And that's why.
Then what happened next was you withdrew with your the commitment to go to the bank. And I think, did you offer to present the bank statements?
No, Your Honor. What we did was to make a formal written notice of withdrawal, Your Honor, because that is exclusively within the privilege of the impeached public official, the Honorable Chief Justice, Your Honor. Now, what is there to compel us? And this is evidence in our favor. Why shall we be compelled to produce? We terminated our cross-examination. So, what is this proceedings now? Will this be redirect or
No, precisely. This court, through this presiding officer, will not allow this witness to be a witness for the prosecution because this witness is coming here simply to comply with an order of this court to produce the documents that you yourself possess for the information of the court.
Yes, Your Honor.
So if you are going to present this anyway in your evidence in chief, when your turn to present the evidence, I see no harm for these documents to be presented to the court in compliance with its order. So that is the position now, and I order the presentation of the documents to the court without being marked by the prosecution.
Thank you, Your Honor.
Order.
With that clarification.
May I make a manifestation, please, Your Honor? We are not adopting the witness as correctly observed by the Honorable Presiding Officer, but we are requesting permission to mark the documents as our own in line.
You mark them when they are presented by the defense as your own, if you want to mark them. Do not change the order of presentation. That the defense said that those are their evidence.
May I be clarified? The defense will be surely presenting this when their turn comes.
Do we have any legal obligation to let you know about
Counsel,
in line with the question of the Honor.
Mr. Counsel,
that is our
you are fishing for evidence.
Yes.
No, Your Honor, because
No. Wait a minute. You did not subpoena this evidence.
that is correct, Your
This
Honor.
court use its discretion to bring these documents here.
That's correct, Your Honor.
And the fact that you tried to adapt them for your own is a misrepresentation.
Your Honor.
Now, wait a minute. Don't interrupt me. I know my rules. I've handled more cases than you can imagine.
Yes, Your Honor.
And that is why I'm allowing the presentation of this document to this court for the uses of this court, since these documents will be presented by the defense at the proper time. Now, if you want to mark them as your exhibit at that time, then do it at that time. In the same manner that when you presented your documents, they opted to mark them also as their exhibits. So, you cannot intervene in the presentation of the documents to this court. Order.
Just a humble manifestation,
Go ahead.
very brief, Your Honor. Your Honor, please, I am respectfully invoking the rule that in a trial, whether civil, criminal, administrative, or impeachment, I respectfully submit, any and all document that is produced before the court may be marked by any of the parties, subject, of course, to the control of the court, and subject to any ruling on admissibility that will be made when they are formally offered.
All right. When the documents will be presented by the defense, then at that time, you can do it. You can ask for the marking of these documents as your exhibit if they will not present it.
Another humble manifestation, Your
Yes.
Honor. Your Honor, please, if the Honorable Presiding Officer, I just would like a respectful clarification. The last ruling or the last sentence of the Honorable Presiding Officer was, if the defense will not produce those documents, then we will be at liberty to produce them. Your
No,
Honor.
no. They're already in the hands of the court.
Yes, Your Honor.
Then you can ask the court to present the evidence for your marking at that time.
Thank you very much, Your Honor. We will do that, Your Honor. We will comply with that, Your Honor.
This is understood, the counsel for the defense.
Right, Your Honor.
All right.
We thank you for that, Your Honor. Thank you, Your Honor.
Oh.
Mr. President, we may discharge the witness then
No.
after the submission.
Let the representative of the bank submit the records he was ordered to bring here.
I already submitted the documents to the clerk.
They have already submitted.
Issue a receipt.
Tingnan mo.
Issue a receipt for those documents.
I'm sorry. May we ask permission, Your Honor, that a member of the defense panel go over the documents being...
May we also...
May we do the same, Your Honor?
Both of you will examine the documents.
May the senator judges, Mr. Senate President, be also given access to this document.
Proceed.
Preferably, if we can have a copy later on.
The members of this court can have access to these documents. After all, it was requested by this court for its own uses.
Tapos na? Can we have a copy of this right now, and may we request the clerk of court to give it to us?
You can.
May we be permitted, Your Honor, to make a short manifestation,
Yes.
Your Honor. These documents required by the court to be produced now, in our understanding, are rather confidential because they involve bank deposits, Your Honor. We will therefore request that they be placed in an envelope, sealed for that matter, so that not even the press may illegally use the same by way of showing them in the television shows and so on, Your Honor.
That's a reasonable request.
Thank you, Your Honor.
Okay.
But can we see it before it is sealed, Your Honor?
Yeah, only for the uses of the members of the court, but not for public exposure at the moment.
Can we ask for a 1-minute recess, Your Honor?
Trial recessed.
Habang sinusuri yung mga dokumentong dala ng kinatawan ng BPI Ayala Avenue branch, ano? Professor Avena, parang mainit ang ulo ni Presiding Officer Enrile tungkol dito sa pagmamarka ng mga ebidensya. Related po ata ito doon sa sinabi niya kanina kay Congressman Fariñas na nagfi-fishing kayo eh. Ano ho yung pakipaliwanag nga po, ano bang ibig sabihin ni SP Enrile dito?
Kasi ang punto lang naman ni Senator Enrile, Senate President Enrile ay ganito. Itong mga dokumento nito, Mr. Prosecution, hindi kayo ang nagsabpina. Kaya lumalabas yan dahil yung hukuman ang nag-order dito sa testigo na ilabas. So, ang very technical ang punto lang ni Senate President. Gusto niya na, Mr. Prosecution, kung gusto niyong markahan niyo yan pag ang depensa na ang nagpipresenta nito. Kaya ang sinabi nga ni Attorney Lim hindi kami nakakasiguro na ipipresenta ng depensa yan, di ba? Kung pag hindi presenta ng depensa, kailan pa namin minarkahan? In the same manner, na nung nagpipresenta ang prosecution, ang depensa, pwede rin magmarka. Yun lang ang punto niya.
Pinag-usapan yung pag-adopt ng witness, kung amin ba, pagmamarka na amin, ebidensya namin ito. Ano po ba yung implikasyon kapag in-adopt mo or kapag hindi mo in-adopt yung testigo? Why is it important?
Kasi pag in-adopt mo yung testigo at yung mga dokumento ang prinisinta, no? Yung dokumento na yan, pwede mong i-offer in evidence at magiging iyo na. Sa makatwid, ebidensya yun para sa'yo.
Para suportahan ang kasong sinusulong mo.
Correct. Oo.
Pag hindi mo in-adopt, hindi mo pwedeng gamitin.
Oo. hindi mo ma-offer. Okay? So tama si Attorney Lim na yung sinabi niyang rule, no, na in any case at all, pag may pinipresentang dokumento, pwedeng i-adapt at pwedeng markahan, no, ng isang partido. Ang question dyan is, pwede ba yan kahit ang korte mismo ang nag-order? Sa akin, syempre, kasi with more reason. Kasi kapag ang korte mismo ang nag-order niyan, hindi na kailangan i-offer. Judicial notice na yon. Ang ibig sabihin ng judicial notice, yung korte na mismo ang nagde-desisyon na aalamin namin ang laman yan at kami na ang maghuhusga kung anong ibig sabihin ng laman yan.
So regardless kung wala nag-adapt?
Yes, oo.
Either sa magkabilang panig,
yes,
i-consider yun ng
correct,
korte.
under the doctrine of judicial notice.
So hindi kailangan lumabas doon sa direct examination ng prosecution. Hindi yung ebidensya, pwede nila, kunyari, galing siya sa pagtatanong ng senator judge, pwedeng gamitin yun ng prosecution for themselves kahit na hindi sila yung nagpalabas ng ebidensyang yun.
Yes, totoo yun. Pero naniniguro siya. Kapag gusto niyang markahan yan at i-adapt niya, naniniguro siya na nasa record for himself. So, yun lang naman ang punto. Kasi pwede yung kabila, baka ipa-strike out niya, may mga taktika yan na ganyan eh. So, to avoid that, yun ang ginagawa ng prosecution.
Ito ho, what if offered na yung evidence like sa kaso ni PS Bank President Garcia, what will happen to his testimony? Gayong hindi ho pinahintulutan ng korte na i-adapt siya ng prosecution as witness.
Sinabi ni Senate President, hindi pa pinapahintulutan ngayon, kundi saka na. You see, in other words, saka na namin irurule yan. So they're keeping their cards close to their heart, no? Hindi pa pinapasilip ko ng decision nila. Pero hindi niya sinabi definitely na bawal yan.
Okay.
I-resolve later on. Ang totoo niyan, he could have resolved it yesterday. Katulad ng ginawa ngayon, di ba? Kaya lang dahil nga may mga tarheta na ayaw pa nilang ilabas, yan ang nangyayari.
Pero tulad nga po na nabanggit ninyo, kahit walang mag-adapt man yan na magkabilang panig, yung court, on the doctrine of, ano po yun, judicial notice, yes, pwede ho pa rin i-consider.
Dapat. Kaya lang ito na nga sinasabi ko eh. Maraming taktika riyan, may mga gray areas sa rules nila na hindi natin alam. Hindi natin alam, baka sa susunod, bawiin nila yun, sabihin lang, we will not take judicial notice. Makakareklamo ba tayo?
So ano ho yun? Nakalutang lang yung ebidensya. Andun lang, walang nag-adapt.
Correct, walang nag-adapt. Pero yung court dapat judicial notice yun, di ba? Pero dahil ang hukuman na yan nga, liberal masyado, or in terms of legalities, kapag gusto nilang stricto. Pag gusto nilang wag sabihin sa tao kung anong decision nila, saka na yan. Laging ganun, di ba? We will resolve it at the end of the game. Diba? Maraming ganun eh. Kapag sinabi nila yan, we will resolve at the end of the game, wala tayong alam, di ba? So, kahuli-huli yan, saka sila magdedesisyon, acquit or convict, na kasama na lahat ng mga nakabitin na issue, hindi natin alam kung bakit.
Kung ginamit yung ebidensya na nakalutang or hindi.
Correct. Di ba? Sa kahuli-hulihan, pag nag-decide sila whether convict or acquit, mayroon bang batas na nagsasabing, sabihin mo lahat ng dahilan mo kung bakit?
They're not. Hindi naman sila kailangan mag-explain kung bakit sila bumoto ng gano'n, di ba?
Nasa ano na lang nila yon, nasa politika na lang nila yon, di ba? Kung gusto nilang mahalin sila ng tao, papaliwanag nila.
Tsaka,
so wala silang pakialam.
So at the end of the day, kapag lumabas na siya in court, kahit na hindi pa siya offered or hindi pa siya admitted in evidence, lumabas
nasa consciousness
na
yun.
Nasa
at the back of your head, may nabasa akong ganito, may narinig akong ganito.
Correct. Kaya nga nasa sa tao na yon na isipin din, no, kung iintindihin niya ba yung sinasabi ng kabila o hindi. Kasi ang sinasabi ng kabila nga is, hindi pa yan, yung documentary evidence, hindi pa yan tinatanggap ng hukuman bilang basehan ng pagdesisyon. Iba yung testimonial, ano? Yung testimonial, tanggap na kagad yan pag walang objection eh. Okay? Yung documentary sa bandang huli yan. Okay? So, ang punto lang naman may karapatan ba ang prosecution na malaman ng taong bayan kung ano nang prinisinta nila? Ang sagot dyan, oo. Huwag mo lang kakalimutan na mayroong kabilang panig. Di ba? Yun lang. Kasi sa demokrasya, ang estilo ng demokrasya ilabas ang lahat at manalo ang katwiran. Hindi katulad sa diktadurya, itago mo ang lahat, di ba? At sorry na lang ang taong bayan. Hindi, baliktad ng demokrasya
Manalo ang katwiran, pero yun nga ho, yung katwiran na yun, maraming kumukontre. Saan ba galing yung katwiran na yun?
Good question, Ivan. Because if you look at mature democracies, ang kanilang mamamayan marunong gumamit ng sentido komon. Makita natin yan kahit France, Germany, Canada, US, masdan mo ang demokrasya nila. pagalingan sila ng katwiran. At ikaw bilang taong bayan, gamitin mo sentido komon mo. Hindi pwede sabihin porque hindi ka abogado, hindi mo naintindihan. Hindi totoo yun, di ba? O, pinanganak tayong lahat na may sentido komon, regalo ng Diyos yan.
Tulad ho halimbawa, balikan ko na naman yung mga bank documents, may nagsasabi illegally acquired daw or acquired using illegal means. So dapat i-exclude daw sa paglilitis na ito dahil illegal.
Okay. Pwede bang ipaliwanag yan?
Sige ho,
kasi
go
medyo
ahead.
mahaba-haba yan.
Mukhang napatagal yung Senate minutes natin. Go ahead, Professor.
Okay. Dalawang klaseng dokumento ang intindihin natin na pinag-uusapan dito.
Okay.
Ang una ay yung nakadikit doon sa supplemental request for subpoena. Na
Yung
sinasabi,
Annex A na tinatawag.
Correct.
Okay.
Na sinasabing peke. Isa yan. Yung pangalawang set of documents ay yung mga bank certification na kung saan nakalagay doon yung mga account number, kaninong pangalan at magkano.
Okay.
Kung kailan binuksan, kailan sinara, di ba? Lahat yun ang detalye nasa bank certifications. At yung bank certifications na yan, lumabas dahil prinisinta ng witness, dahil hiniin ng senador, dahil hindi bawal, dahil impeachment ito under Republic Act 1405.
Okay.
Tama? Okay. So, dalawang klase yan. Yung lumabas sa hearing dahil hiningi ng mga senador, okay, ay wala ng koneksyon doon sa nauna. Actually. Bakit? Kasi nga, hindi naman yan nilabas dahil sa subpoena eh. Nilabas yan dahil hinihin ng senador. Correct? Alright.
Okay.
So, ngayon, yung una na sinasabing peke, bakit ini-insist yan? Bakit naging issue? Bakit nagtatagal ang tuon ng pansin dyan? Okay, maraming motibo. Okay? Pero itignan na lang natin yung epekto. At tignan natin ang legal na basehan na sinasabi ng depensa kung bakit yan ay issue. Okay. Ang unang epekto na makikita natin dyan ay naantala ang trial. Dahil kung titignan, tapos ng prosecution sa kanilang presentasyon sa Article 2. Lumabas na sa kanilang paningin, ha? Tama na ang lumabas na ang SALN. Lumabas na ang deeds of sale ng mga bahay at lupa at condominium. Lumabas na ang income tax return. Sa makatwid yung legal mo, no? Nakita. Lumabas na, ito na yung ikaapat, yung bank accounts. Oo. So, sa makatwid, ngayong lumalabas na yung mga details ng bank accounts, saka pumasok itong issue na ito. Bakit? Okay? Kasi ang depensa, mayroong position dyan. At yun ang ikalawang punto ng epekto. Kasi ang unang punto, delay, no? Yung pangalawa is, nalilito tuloy ang taong bayan. Kasi ang tanong dyan is, may connection pa ba ito sa impeachment o wala na?
Yes, SALN pinag-uusapan natin dito, yung truthfulness and accuracy, di po ba?
Correct. Now, of course, ang depensa, itong sinasabi. May connection yan. Bakit? Dahil kapag itong subpoena mo, hinain mo sa basihan, at ang basihan ay isang peking dokumento, sa paningin nila, okay, lahat ng makalat na dokumento dahil sa subpoena mo,
ay peke na rin.
Hindi naman. Kung hindi, dapat hindi tanggapin.
Yes,
exclude. Bakit daw exclude? Kasi ginagamit nila yung doktrina ng fruit of the poisonous tree. Sa makatwid, ibig nilang sabihin, kung ang basihan ng paglabas niyan ay ang subpoena, na ang subpoena ay defective dahil, di ba, nakadikit doon ay peke, okay? Lahat ng lumabas dahil doon, hindi na dapat papasukin. Yan ang sinasabi nila. Kaya, kung titingnan natin, huwag natin kalimutan, yung doktrinang yan ay para sa criminal case.
Ito ho ay impeachment.
Oh, hindi ito criminal. Okay?
Now, pag-usapan natin ulit yan. Kaya attorney, balikan muna natin ngayon ang impeachment proceedings.
Matter.
Go ahead.
On the prosecution manifest that we will not anymore present the witness from the National Statistics Office, namely Ms. Editha Orsilia, because on the pre-marking last 30 January 2012, attended by the defense, a certain Dexter Corpus, and the prosecution, Manuelito Luna, the defense has stipulated on the authenticity of the documents. Namely, the birth certificate of Maria Carla Corona, Exhibit 6 S for the prosecution, the birth certificate of Francis Corona, Exhibit 6 T, marriage certificate of Constantino Castillo III and Maria Carla Corona, Exhibit 6 U, and birth certificate of Maria Charina Corona, 6 V, for the prosecution. So we just want to manifest that, Your Honor.
You have stipulated with the defense on this?
Yes, Your Honor, the defense can confirm it.
All right.
If they wish to. A certain Dexter, Attorney Corpus was present and stipulated as the authenticity of those documents. That's the reason why the prosecution will not anymore present that the witness from the National Statistics Office, Your Honor.
So
we thank the defense for stipulating.
You offer that at the proper time when you make your offer of evidence.
That's correct.
Right.
Thank you.
Next witness.
Before we, so now we proceed, Your Honor. We leave Article 2 of the impeachment complaint.
When you say you leave the Article 2, are you through with the presentation of your evidence in chief
Yes, I'm about to say that, Your Honor.
On Article 2?
We'll leave Article 2 with the reservation. Reservation on the foreign currency account, subject of the temporary restraining order issued by the Supreme Court, and also with the reservation earlier on the 6 accounts, 8 accounts, rather. It's 8 accounts from the PSB bank as testified by the President, because we were required by the Honorable Presiding Officer to submit a memorandum to that effect. So with that reservation...
What memorandum was that? I cannot remember.
This is regarding the testimony, Your Honor, of the President of the PS Bank.
Yes.
Because we wanted to mark as our exhibits the 8 accounts produced yesterday by the President of the bank. But we were required by Your Honor to submit. And with that reservation, we leave Article 2 and we'll proceed now to Article 3. And we would like to request, Your Honor, that one of the members of the public prosecutors, Congressman Sherwin Tugna, be recognized.
The named lawyer is recognized.
He's a member of the prosecution panel, Your Honor, Congressman Sherwin Tugna.
Thank you, Mr. Presiding Justice. Good afternoon, Your Honors. We will now continue with the presentation of Article 3. And for our next witness, we will call on the Vice President of the Philippine Airlines, Vice President for Sales, Mr. Enrique Javier, Your Honor.
Proceed. Bring the witness in.
Now, to put the record straight, Your Honor, the Honorable Public Prosecutor mentioned our next witness. There is no witness yet.
No,
this is the first witness, Your Honor.
That's correct. That's lapsus in memoriam.
Yeah, but just so the journal will speak.
If I may,
Mr.
Presiding Justice, the Public Prosecutor, Congresswoman Bagao, has already presented a witness for Article 3, and it was Mr. Bob Anduisa, Mr. Presiding Justice.
So his testimony is also in support of impeachment Article 3. That's correct. Is that right? You confirm that, Mr. Counsel?
Yes, Mr. Presiding Justice.
All right.
Thank you, Your Honor.
So that's settled. Bring the witness in.
Mr. Presiding Justice, if I may.
Yes.
I am calling on Private Prosecutor Attorney Marlon Manuel to conduct the direct examination.
Attorney Marlon Manuel may now proceed to handle his witness. Let the witness take the witness stand and be sworn.
Please raise your right hand, Mr. Witness. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, Your Honor.
So help you God.
Your Honor, we offer the testimony of the witness to prove that while the case entitled Flight Attendants and Stewards Association of the Philippines, FASAP, versus Philippine Airlines Incorporated, Patricia Chong, in the Court of Appeals, GR number 178083 was pending before the Supreme Court. Chief Justice Renato Corona and Mrs. Cristina Corona received special privileges, including free plane tickets from Philippine Airlines. The witness will also identify documents covered by the Senate subpoena. May I proceed, Your Honor?
Proceed.
Magandang hapon po, Mr. Javier.
Magandang hapon din naman.
Maaari niyo bang sabihin ang inyong pangalan, edad at tirahan?
Ako po si Enrique Javier, 53 years old, at naninirahan sa Capitolio, Pasig.
Salamat po. Maaari niyo bang sabihin kung ano ang inyong trabaho sa kasalukuyan?
Ako po ang Vice President for Sales ng Philippine Airlines.
Gaano katagal na po kayo Vice President ng Philippine Airlines?
At this juncture, Your Honor, with the kind permission of the Honorable Court. If Your Honor, please.
Yes.
We have a motion to quash the subpoena against this witness, Your Honor, on the humble submission that his testimony will be irrelevant, immaterial, and impertinent to the subject matter of the case, Your Honor.
Why irrelevant and immaterial?
It is not, Your Honor, please, this witness is allegedly being presented in connection with Impeachment Article 3, Your Honor.
Correct, and that's why I was reading it.
And there is no mention about the alleged plane tickets mentioned in here, Your Honor. I'm sorry.
I will read I will read Article 3. Respondent committed culpable violation of the Constitution and or betrayal of public trust by failing to meet and observe the stringent standards under Article 8, Section 7.3 of the Constitution that provides that members of the judiciary must be a person of proven competence, integrity, probity, and independence in allowing, this is the charge, in allowing the Supreme Court to act on mere letters filed by a counsel which caused the issuance of flip-flopping decisions in final and executory cases, semicolon, in creating an excessive entanglement with Mrs. Arroyo through her appointment of his wife to office, semicolon, and in discussing with litigants regarding cases pending before the Supreme Court. Now, counsel for the prosecution, what's the relevancy and materiality of this witness to this charge?
Yes, Your Honor. The presentation of the testimony of the Vice President of Philippine Airlines that the respondent and his wife receive free travel benefits, special privileges while a case is pending in the Supreme Court, Your Honor, need not be alleged, Your Honor, in the complaint, because, Your Honor, these are mere statements of evidentiary facts which constitutes as the reason for the impartiality of the respondent in favor of Philippine Airlines. Philippine partiality, Your Honor. I submit, Your Honor.
We deny this witness. It is not relevant to Article 3.
Your Honor, if I may, Your Honor.
I just read to you Article 3 of your impeachment. This is the one that is going to be voted upon by the members of this court. That there's no allegation in Article 3 that you allege about perquisites or favors.
If I may, Your Honor, just for a minute, Your Honor, please.
Yes.
Please. Your Honor, the charge in Article 3 is that the respondent culpably violated the Constitution and betrayed the public trust because he lacks independence and integrity, Your Honor.
Yes.
And
wait a minute, but
if I may be.
Wait a minute. The court speaks. You stop. You read your article, the way you framed your Article 3. Huh? Yeah, I know that you are a literate person. And it says, you are quoting Section 7, Paragraph 3 of the Constitution that provides that a member of the judiciary must be a person of proven competence, integrity, probity, and independence and the rest. In that, 3 charges, 3 allegations. In that, in allowing the Supreme Court to act on mere letters filed by counsel which caused the issuance of flip-flopping decisions in final and executory cases. That's one. In creating an excessive entanglement with Mrs. Arroyo through her appointment of his wife to office. And that's another one. And in discussing with litigants regarding cases pending before the Supreme Court. Now you're expanding the coverage of this article. This court will not allow the expansion of this article unless you amend it. So ordered. God.
Your Honor, just...
What?
If I may be allowed, Your Honor, to just to expound on the matter, Your Honor, why we were...
The court has already ruled. You are wasting the time of this court. My God, we have to have some discipline in here. You made allegations and you are going to expand it without charging, without the proper charges in your Article 3?
Your Honor, I understand that you have already made a ruling, but if I may, Your Honor, if I may just explain for a minute, Your Honor, why this matter is being sought to be introduced.
Then, if you want to introduce that, amend your articles of impeachment.
Your Honor, if I may, Your Honor, the presentation of this testimony is relevant because, Your Honor, it will help establish the partiality of the respondent in favor of Philippine Airlines, Your Honor. I submit, Your Honor.
But you did not allege it here.
Your Honor, if I may, Your Honor, if I may explain.
Well, the court has ruled, so that's it. You take me to the court.
Mr. President, we may now discharge the witness.
The witness is discharged.
May I ask the prosecution for if there are any other witnesses?
I already told you that this is the trouble of your articles of impeachment. You are not very careful in your allegations, and you want to expand it in the course of the trial. And I've warned you several times.
Your Honor, although there is a ruling...
No, there's a limit to the patience of this court.
Your Honor, motion to confer with other client, with other counsel, Your Honor.
You may. Session trial suspended for 1 minute.
May we expand the suspension, Mr. President, to 10 minutes?
All right, 10 minutes suspension.
Okay, kakatapos lang na i-deny ni Senate President Enrile itong testimony nitong bagong witness ng prosecution, itong si Enrique Javier, Vice President for Sales ng Philippine Airlines.
Professor, ano ho ang implikasyon ng hindi pagtanggap ng korte sa Vice President ng Philippine Airlines kaugnay ng Article 3?
Sa pagbasa ko sa Article 3, tama naman si Senate President. Kasi the reason is, sinabi ng Article 3, the Supreme Court, Chief Justice Corona was partial in some, para ang spirit niyan Chief Justice Corona was partial in allowing. Yun ang nakalagay in allowing.
Yes,
So makatwid yung charge nila in terms of the Constitution being violated ay inexplained through certain acts.
Tatlo yun. Yun. Yung sinabi na hinayaan in allowing the Supreme Court to act on mere letters filed by counsel which caused the issuance of flip-flopping.
In allowing.
Okay.
Tapos in creating excessive. Tapos yung pangatlo, in
discussing.
You see? So yung tatlong yun ang sinasabi nila na pamamaraan kung paano ka naging partial.
Pero ang sinasabi nila, itong witness na ito, ang ititestify niya ay yung pagtanggap nitong si Umuno ni Chief Justice ng mga
Privilege.
privileges from
So,
PAL.
sana sinabing ika-4 yun, di ba? In accepting privileges. Kasi yan
While
sinabi.
a case is ongoing.
Oo,
Ganun dapat.
oo. So talagang, I think tama si Senate President sa punto ito ngayon, na talagang hindi kasama sa Article 3 yung testimonya. Hindi katulad nung dating issues na mukhang naging medyo stricto. Ngayon, palagay ko, tama lang talaga interpretation ng Article 3.
Tapos paulit-ulit sinasabi ni Senate President Enrile, amend your articles. Pwede pa ba talagang i-amend yung articles of impeachment at dapat ba nilang i-amend na ito?
Ang implication yan, kung gusto mong i-amend, isusoli mo yan sa House of Representatives. Di ba?
Babalik sa proseso na naman.
Same, yes.
Justice
Tas
Committee.
bobotohan.
Pero may 1-year ban ho.
Paano? Doon sa... Hindi.
Mag-a-apply po ba yun?
Hindi, kasi amendment lang to eh. This is not
amendment
a new
lang.
charge. Pero look at the delay.
Tsaka yung embarrassment. Ano ho? Well, as it is, parang on several instances today, in today's trial, para ilang beses so sinabi ni Senate President Enrile na magulo yung articles of impeachment nyo. I've warned you several times. Ano hong nakikita nyo dito? Nauubusan na rin ba ng pasensya itong si Senate President Enrile? Ano hong basa ninyo?
I will demur to that. Ang pakiramdam ko lang naman is, tama siya sa puntong ito. Kung pupunta tayo sa ibang punto sa nakaraan, I am not sure about that. No? Kasi maraming occasions in the past, napalagay ko, naging masyadong stricto ang hukuman eh. Mas stricto pa kesa sa criminal case. At yun ay nakakapagtaka. Kasi talaga impeachment ito eh. So, hindi dapat stricto.
Balikan ho natin yung naudlot nating talakayan
Discussion
kanina tungkol ho dun sa mga bank accounts. Tapos i-connect ko rin sana itong sinabi ni Senate President Enrile. We are using a compulsory process to get evidence for you. Kayo, fishing lang kayo ng fishing eh. Kahit ano yung pamamaraan, gaya nan, lumalabas nga daw na may questions dun sa authenticity ng mga documents sa pinanggalingan nung subpoena.
Na-mention ba natin yung tungkol sa sinabi ko na fishing expedition in fact is allowed sa civil case saka yung kay President Bill Clinton na impeachment? Nasabi natin?
Hindi pa ho.
Okay.
Ganun po ba?
Good. So, yun ang unang titingnan natin. Impeachment proceeding ito. Kaya yung mga rules of court na akala mo stricto sa ibang kaso, suppletory lang. But the truth is, kahit sa ordinaryong kaso, hindi ganun ka-stricto yan. Lalo na in a civil case. Sa civil case, fishing expedition is allowed. It is.
Tulad halimbawa ho paano? Nung fishing expedition na tinutukoy natin sa civil case.
Meron tinatawag na discovery proceeding. 5 klase yan. Pero yung applicable dito, 4. Meron tinatawag na request for admission. Na kung saan isang partido, diretsyong magbibigay sa kabila ng isang request na ang tanong pwede bang aminin mo kung totoo o hindi ang the following? Fact 1, Fact 2, Fact 3. Pwede rin naman na ang dokumentong naka-attach dito ay genuine. Okay. Pwede ba aminin mo yan? Under oath yun, number 1. Pangalawa, interrogatories to parties. Ibig sabihin yan, magbibigay ka na naman ng papel doon sa kabila na may mga enumerated questions. At yung enumerated questions na yan, pwedeng kahit ano, tanungin mo, katulad ng, meron ka bang bank account sa bangkong ganon?
Nang ganon ka diretsahan?
Yes, at detalyado pa. Kung mayroon man, paki-enumerate, pakisabi nga yun, etc. Okay, number 3, request for production and inspection of documents and things. So halimbawa, merong banggaan. Sabi mo, pakita mo nga sa akin yung coaching na bangga. O kaya, sinasabi na merong nakatagong mga infringing materials pagdating sa trademark, copyright, o kaya patent. At sabihin nung kabila, gusto kong makita yung bodega o warehouse mo. Tingnan ko nga lahat ng mga disk mo dyan, kung nag-infringe yan o hindi.
So kahit na hypothetical, kahit na yung mga questions, okay
meron
lang?
3 limit. Kinakailangan relevant pa, pangalawa, medyo specific naman.
Right.
Para guided. Ano ba hinahanap namin sa bodega? Hindi naman lahat ng... Okay. Pangatlo, hindi privileged. Walang rule o regulation sa batahan nagsabing, huwag mong tingnan yan. Katulad nung, let us say, yung dollar accounts. Ayan, isang example yan. Basta yung 3 yan ay makomply mo, pwede kang mag-fish. Ika-4, di ba? 3 na nasabi natin. Ika-4, deposition. Ang deposition ay pamamaraan na kung saan kukunin mo ang testimony ng isang testigo na nasa labas ng korte. Halimbawa, meron siya sakit. O kaya ang hukuman napakalayo sa bahay niya. Taga-Sulu siya, samantalang korte, Quezon City. Yan, pwede mong puntahan yan sa Sulu. At doon, under oath, mayroong notaryo publiko o other official na kukuha ng kanyang deposition. Okay? may regulasyon talaga kung magagamit ba yan o hindi, no? Kasi yung deposition na yun, discovery yun eh. Hindi agad ebidensya yan, hindi pa. Pero pamamaraan yan na pagdiskubre ng posibleng ebidensya mo.
So, malinaw din po ba sa rules on impeachment na pwede rin ang mga ganong klaseng pamamaraan ng pagkuha ng ebidensya?
Malinaw in the sense na hindi bawal. Ang sinasabi
walang prohibition o walang pagbabawal.
Oo, lalo na hindi. Ang sabi nga, impeachment is not criminal, not even civil, ayaw din sabing administrative. Eh di ano yan? Ang giya mo dyan is ano ang spirit ng Constitution. Ang spirit ng Constitution, ang impeachment is a way of holding a public official responsible, accountable, no, and transparent. Kasi nga, yung pwesto niya, hindi pagmamayari. It is not life, liberty, or property. No. It is only a position na pinahiram sa'yo para pagsilbihan mo ang taong bayan dahil sinesweldohan ka nila. Sa bakit pag nawala ang tiwala sa'yo, pwede ba iba na lang ilagay namin dyan? Dahil lumabag ka, no, sa tiwala namin. Yan ang nature ng impeachment.
Okay. Sige. Mamaya tutuloy pa rin po natin ang ating talakayan. Samantala, tuloy-tuloy pa rin po ang balitaan dito sa GMA News TV. Narito ang iba pang mga balita sa oras na ito. Naniniwala ang pulisya na matibay ang hawak nilang ebidensya para masampahan ang reklamong murder kaugnay ng anti-hazing law ang dalawa sa mga suspect sa likod ng pagpatay sa law student ng San Beda College. Hawak ngayon ng Antipolo Police ang mga suspect na sina Eric Castillo at Boji Iap. Nakilala na rin ang lalaking nasawi umano sa hazing sa Antipolo na si Marvin Reglos, freshman law student ng San Beda College. Ito'y sa tulong ng isang anonymous caller na nagbigay ng pangalan ng biktima. Hinanap ng pulisya sa Facebook ang pangalan at ikinumpara ang litrato nito sa biktima. Kwento ng pinsan ni Reglos na si Delilah Ayap, sinabi raw sa kanya nito sa isang text message na pupunta siya sa initiation ng Lambda Rho Beta Fraternity. Domestic helper sa Korea ang ina ni Reglos, magsasaka naman sa Isabela ang kanyang ama. Ayon sa mga otoridad, kinilala ng gwardya ng resort sa Antipolo kung saan pinaniniwala ang isinagawa ang di umano'y hazing ang mga suspect ni sina Castillo at Yap. Narinig din daw ng gwardya na isinisigaw ng grupo ng mga lalaki ang pangalan ng fraternity. Nasa 15 pang suspect ang pinaghahanap ng mga otoridad. Sa iba pang balita, 3 sugatan matapos pasabugan ng granada ang isang boarding house sa Carmen, Davao del Norte. Kwento ng isang biktima na nakikipag-inuman lang daw siya nang mangyari ang pagsabog kaninang madaling araw. Hinala niya ang mag-asawang kasama niya sa boarding house ang umano'y target ng mga suspect. Sa investigasyon ng pulisya, isang MK1 hand grenade daw ang ginamit sa krimen. Ginagamot sa ospital ang mga biktima. Patuloy naman tinutugis sa mga otoridad ang mga suspect. At yan po ang iba pang malalaking balita sa oras na ito. Balik tayo sa ating talakayan. Kasama pa rin si Professor Victoria Avena.
Pero ma'am, kanina po, sinabi ni Senate President Enrile sa prosecution panel na kung ang gusto daw nating style ay yung parang grand jury na pwede ngang magtanong ng kahit ano, dapat daw kasi hinanda na muna yung ebidensya. Pero it seems daw, according to the Senate President, na wala daw nakahandang malinaw na ebidensya ang prosecution at lahat ng ebidensya ay kinukuha pa lang daw nila ngayon during the course of the trial. Yan yung sinabi niya kanina.
Well, in fact, matagal na sinasabi yan ng Senate President. Ano? But as again, para sa akin, kung titingnan mo, even civil cases, okay, will allow fishing expedition. Ang kinakailangan lang, no, sa isang civil case ay you allege ultimate facts sa makatwid sa iyong complaint, sa reklamo mismo. Hindi mo dapat ilagay doon yung mga ebidensya mo. Ang sasabihin mo lang yon ay yung punot dulo na at mga elemento ng reklamo mo. Yun lang pinaka-basic. Yun lang ang sasabihin mo. Kung kumbaga nagkaroon ng banggaan at gusto mong humingi ng danyo, sasabihin mo lang sino ang involved sa banggaan, kailan nangyari to, ano yung nabangga, ano yung plate number, gano'n. Hindi mo na kailangan sabihin ang kulay ng kotse blue. Hindi mo na kailangan sabihin.
So pwedeng kahit yung Senate mismo, parang nag-iimbestiga rin sila. In a way, parang ganun ba?
Kasi, dalawa yan. Pagsampa mo ng reklamo, hindi kailangan ng ebidensya. Ang kailangan lang sabihin mo sa reklamo mo, yung mga basic na elemento ng reklamo mo.
Yun ho yung tinatawag na ultimate facts.
Oo, pag sinampa.
Okay.
Ngayon, pag nagkakaroon na ng trial, okay, yung mismong partido na nagsampa, pwede siya mag-fishing expedition. Ngayon, habang nag-fishing siya, yung korte pa mismo, yung korte, pwede bang magtanong doon sa mga testigo na hinahain mo? Pwede. Okay, pero ano ang larger picture, no? Pwera pa sa trees, when you look at the forest, dahil impeachment ito, ang talagang punto dito is, yung meron bang nakikita sa pagtatanong at paglalahad, meron bang nakikitang dahilan para mawala ng tiwala ang tao? Yun lang ang tanong dito eh. So, bakit ko sinasabi yan? Binabalik ko sa konteksto dahil gusto ko ikumpara nga doon sa impeachment ni former President Bill Clinton.
Okay.
Kung maalala natin.
18 days lang daw po yun eh. Itong impeachment trial ni President Clinton.
Yes. At if I may say, si former Chief Justice sa Panganiban, mayroon siyang sinulat sa Philippine Daily Inquirer na nagsasabi na kahon-kahon nga ang dokumento ng prosecution dito eh. Pero hindi kinailangang isa-isahin ng testigo sa hukuman mismo. No? Pangalawa, si President Bill Clinton mismo naupo at inexamine ng ilang oras. So, ang sa akin, mantakin mo yon. Presidente yan ng pinakamakapangyarihang demokrasya sa buong mundo, pero dahil matibay ang kanilang demokrasya, pinaupo yan. At inexamine ng ilang oras. Kahit kanda hiya-hiya, di ba? Medyo nakakahiya na yung mga tanong eh. Yes. Lalo na ang issue nun, medyo private, di ba?
Kung ganun hong allowed nga po yan, ano naman yung karapatan ng akusado para ipagtanggol ng kanyang sarili? Tulad po halimbawa nito yung kampo ni Chief Justice Corona, paano nga naman niya i-dispute yung mga lumulutong na ebidensya laban sa kanya?
Ganito yun. Hindi ba tatanungin siya ng prosecution? Tatanungin din ng mga senador. Yung mismong testigo, yung mismong defense counsel, pwede magtanong din sa testigo, di ba? Sa pamamagitan ng pagtatanong, lumalabas ang katotohanan. Pangalawa, pag turn na nila, meron naman silang turn after this prosecution. Sila na mismo magpapakita. Halimbawa, sabihin nila na, merong laman yung bank account sa pangalan namin, pero hindi kami may-ari niyan. In trust lang yan. Yun ang sinasabi ni Attorney Esguerra, halimbawa, hindi ba? Pangalawa, pwede lang sabihin na, marami kaming lupain, marami kaming kondo. Pero yan ay galing sa legal na income namin. Yun, no? So
ang sinasabi ho natin, huwag na nating harangin yung pagpupresenta ngayon, you will have your turn later.
Bagamat, ang sinasabi ko nga, ang totoo niyan, ang nangyayari, iba ang gawa sa salita. No? Ito, very frankly, itong nangyayari. Sasabihin nila na mayroon kaming ebidensya at depensa at papakita namin yan.
At the proper time.
Correct.
Lagi nila sinasabi.
Correct. Okay naman maniwala dyan as long as ma-reconcile sa ginagawa ngayon. Dahil ang ginagawa ngayon ay pinipigilan ng ebidensya. Pangalawa, gusto pang ipadismiss sa Korte Suprema. So tuloy, di ba, magtataka ka na parang akala ko ba gusto nyong sagutin? Akala ko ba gusto nyong sabihin sa taong bayan na wala kayong tinatago? Bakit yung pinapadismiss sa Supreme Court? Di ba kasi kapag ganyan ang nangyari...
Dahil may grave abuse of discretion daw po. Kino-question nila yung mismong procedure, yung nabanggit nyo nga ho kanina, procedural yung mga tanong ni Justice Cuevas.
Yun na nga. Sa makatwid, gumagawa ng... Ang tinatahak nila ay parang teknika ng legalidad. Di ba? Mga procedure ng batas para iwasan. Pero sa makatwid, at the end of the day, sa katapos-tapusan nito, pagdating sa simbahan, malayo man ang tinahak.
Yung mahaba man ang prosesyon.
Pagdating sa dulo, ang tanong dyan, may tiwala ka pa ba? Kung mayroong 5 bank account na dolyar ang laman, tapos hindi mo alam kung saan galing yan, anong laman, lahat yan, hindi masasagot kapag na-dismiss ito. Palagay na, ang Supreme Court sinabi, stop it. Right? Hindi lang TRO, injunction pa, dismiss pa. Parang, diba, wala kayong karapatan. Kung sinabi ng Supreme Court, sabihin na, kahit ano pang dahilan niya, mistrial, violation of due, lahat na sabihin ng Supreme Court, tigil na yan. Di, ang dami nakabitin na tanong sa isip ng tao at yung nasasakdal, nakaupo pa rin. Masaya ba tayo na yung nasasakdal, nakaupo pa rin, samantalang yung salin niya, hindi pinaliwanag lahat ng lumalabas na ari-arian. Gusto natin masagot yan, hindi ba? Yun ang punto. Kaya disadvantage ang ginagawa ng depensa sa sarili nila, di ba? Kung hindi nila ipaliwanag at pigil ng pigil.
Parang baka may tinatago. Ganon yung iniisip ng mga
dahil
tao.
sa perception, yun yung
perception.
Because it's true. May basehan ng perception dahil inamin na merong dollar accounts. Inamin At lumalabas sa mga official documents lahat ito, yung ITR, yung deed of sale, official lahat yan. Magkanong lumalabas na ari-arihan, di ba?
Professor, pag-usapan po natin
pag-usapan naman natin yung
yung
Article 3. Nag-Article 3 na tayo. Ano po ba yung magko-qualify na relevant na isang relevant witness? Kasi kanina nga dinismiss na yung witness kasi hindi nga raw siya relevant doon sa Article 3. Ano yung
who will qualify
as a relevant witness? Ulitin natin yung mga hinihingi lang doon yung tatlo, 'di ba? Na Una, pinayagan ng Supreme Court na mag-flip-flop yung decisions on mere letters from counsel.
Yes.
Pangalawa, excessive entanglement daw with Mrs. Arroyo.
Yes.
Tapos, pangatlo, yung pagdidiscuss daw ng kaso kasama yung mga litigants habang ongoing pa yung kaso. So, anong witness ang pwedeng i-admit?
Yung una kasi, nagsubpoena sila ng mga, I think, Supreme Court justices, saka pati yung logbook ng Supreme Court, di ba? Palagay ko, hindi pinayagan yan at posibleng mag-rely na lang sila sa mga dokumento na official. Yung mismong decision ng kaso, no? At yung mismong on-record na sulat ni Attorney Mendoza. Bagamat ito lang ang hindi ko alam Hindi ko alam kung meron na silang kopya ng sulat na yun Kasi yung sulat na yun, it was referred to in the Supreme Court resolution. Nag-advert, no? Pero yung mismong sulat at laman nun, hindi ko alam kung merong hawak ang prosecution nun. Kaya nga nila sinasabpina
Pero mali po ba para sa isang counsel na sumulat sa Supreme Court kapag final and executory na yung decision?
Okay. Lumalabas na yung sulat per se, ginawa rin ng FASAP. Okay?
Yun na nga So,
pero kaya hindi yun ang problema.
Kampo.
Hindi yun ang problema. Hindi problema yung sumulat Ang problema is yung ang FASAP sumulat, may kopya yung kabila. Samantalang yung PAL, nung sumulat through Attorney Mendoza, walang kopya ang FASAP. At pagkatapos, hindi ka na binigyan ng kopya, kaya wala kang chance mag-respond. Okay? Ang nangyari pa ay in-schedule ni Chief Justice, in-agenda niya, at basehan sa pag-agenda na yun, nag-meeting ang buong en banc na Supreme Court, at yun ang dahilan kaya na-reverse yung dating resolution. Kasi yung dating resolution ng September 11, if I'm not mistaken, 2011, sa resolution na yan, kumbaga tapos na. Pwede nang mag-execute. Pwede nang i-implementa. Kasi nanalo yata sila ng, magkano ba? 14 billion? I'm not sure, but malaki, billion ang napanalunan
Ng FASAP.
Ng FASAP, oo. Union yan no? At yun ang mga benefits nila. Kung hindi yan na-recall sa pamamagitan ng sulat ni Attorney Mendoza, makukuha na nila yun, pera na yun Pero nung ni-recall at sinabi, wag mo na i-implementa yan dahil pag-aaralan pa yung MR. Okay, yung motion for reconsideration, pag-aaralan uli. O kaya nakapending uli. Kaya nakabinbin uli. So, kaya yung pera naging bato.
So, ang challenge ngayon sa prosecution ay i-prove na kaya bumaliktad ng desisyon ay dahil dun sa sulat.
Hindi kailangang pruebahan dahil nandun sa record
Okay.
Nandun sa resolution ng Supreme Court sinasabi, base sa sulat ni Attorney Mendoza, okay, nire-recall natin. Yun ang sinabi. We are recalling.
Okay.
Kaya nga ang sa akin, umihingi lang sila ng testigo para kumpletuhin ang picture. Pero mayroon na ang basehan talaga. Kasi official documents yan Supreme Court resolution yan, Supreme Court decision yan, etc. Yung pangalawa naman, I think yung sa Camp John Hay.
Yung pagkaka-appoint ni Mrs. Corona.
Meron din mga official document, appointment, official yan, etc. No? Pero siguro yung mga ibang parte yung ibang bahagi ng litrato, kailangan din ng witness para makumpleto yan. Oo. Pangatlo, I think yung kay Mr. Lauro Visconde. Ayan. Well, obviously, kailangan talaga ng testigo dyan. Siya mismo at si Mr. Yung sa VACC, no?
Si Mr. Jimenez,
Dante Jimenez, yes.
At una nang napaulat naman na pupunta talaga sila at titestigo tungkol dito sa
Kasi bawal po talagang makipag-usap? Ganun po ba?
Oh, yes.
Ano po ba yung nasa batas?
I'm sorry?
Bawal po na makipag-usap ang...
Oh, yes. Siguro, alimbawa, pag nakita kayo sa binyag, o kaya sa party o sa cocktail, siguro pag hi, hello, hindi naman masyadong masama yun dahil nakikita ng lahat. Pero yung in private, magmi-meeting kayo at walang nakakalam anong pinag-usapan nyo, question mark talaga, bawal na bawal yun. In fact, dalawin ka ng litigant.
Kahit ma-surprise, ganun. Na-surpresa ka.
Dapat bawal.
Dapat i-refuse mo. Ganun po ba?
Lahat ng mga personnel ng Supreme Court, dapat nakatimbre yan na sinong tumitimbre sa aking pintuan at gusto akong ma-meeting? Bawawalan mo, maraming security guard doon, maraming sekretarya doon na
totoo.
Hindi ka makakarating sa pintuan.
Mahigpit nga yung mga security sa Supreme Court. Attorney, nasa Article 3 na tayo, tumagal tayo ng isang buwan at ilang araw dito sa Article 2.
Yes.
Do you expect Article 3 to be smoother sailing than Article 2?
Yes.
With respect to
at mas mabilis.
The prosecution?
Yes. Look, ilang oras ang hearing minsan? 5 hours, di ba?
Yes.
Sa 5 hours na yan, dapat matapos yan. Kaya yan Kung hindi lang technical yung mga objection, hindi ba? Kasi, I don't know, but if you really ask other lawyers, yun talagang litigator, ganito yan eh. Sa umpisa, nagigirian ang mga abogado. Pagalingan yan, nagkakapaan yan, lalo pati yung judge kinakapaan. Sa first 30 minutes, maraming objection yan. Pero pagkatapos nun, wala na halos pumapayag na yung judge na yung maliliit na objection mo, wag na. Bakit? Tungkol lang sa form yan eh. Kaya wag lang yung sobra, no? Na pati chismis, papapasukin mo na. Wag lang yung mga major objection. Pero yung objection tungkol sa form of the question, di ba? Pinapalagpas na yan sa korte, yun ang totoo. And wala akong naririnig pang major objection really. Okay? Yung mga, I'll give an example.
Mga laid the basis, mga ganon. New major objection yun?
Hindi. In fact, ano lang yun eh. Kaya kita mo, reform the question. You see? Hindi sinasabing don't ask about that. Yun ang major, ha? Di ba? I'll give you an example. For example, pag sinabi nung abogado doon sa testigo, dinala mo ba yung dokumento? Ano sinasabi ng dokumento? Kita mo, objection, Your Honor, sinasabi, the document is the best evidence. If I may tell you, no, yung sinasite nilang doktrina na best evidence rule, walang connection yan doon sa procedure na yon. Kasi ang best evidence rule, ang sinasabi lang, kung meron kang gustong pakitang dokumento dahil ang question na yung laman, okay? Sa doktrinang yan, huwag ka magpapakita ng photocopy. Ang ilabas mo yung original. Kasi yung original lang, best evidence. Di ba? Kasi nga naman, kung photocopy, maaring marami na magic doon, di ba? Kasi ito yung original, burahin mo, tapos i-xerox mo, edi iba na. Di ba? Kaya kapag ang pinag-uusapan yung laman, dalhin mo yung original. Yun ang pakita mo sa korte. Yan ang best evidence rule. Okay? Kaya pag sinasabi na, hawak na nung testigo yung original. Hawak niya na eh.
So, huwag na natin pag-usapan ito na.
Anong laman? Objection or best evidence rule? Okay? Walang connection yun. Kaya, alam mo kung paano yun makikita, totoo? Kasi bakit ganon? Pag yung abogado nagtanong, objection, sustained. Pero pag yung senador nagtanong, lahat pinayagan na. Diba? Basahin mo ng laman yan. Naku, lahat na nag-narrate na from beginning to end. Kitang-kita, di ba? Kasi nga, hindi naman major objection eh.
So ma'am, ito, nag-Article 3 na tayo. So mukhang ida-drop na, hindi na pag-uusapan ulit yung tungkol dun sa AMLAC.
There are in fact reports na titigil na yung prosecution sa Article 7 after Article 3.
Ganun ba yun?
Do you think they have proven enough or they have raised enough
ang
para
prosecution? Para sa Article 2? Absolutely, yes. In fact, tapos na eh. Tumagal na lang dahil doon sa AMLA, BSP na yan. Take note, nag-reserve yung prosecution. 2 reservation nila, no? So, yun na lang. Pag natapos ng 2 reservation, tapos na, and enough na talaga yung napresenta nila. Kahit pa without the dollar accounts, dami nang lumabas, di ba, na talaga na-pruebahan nila.
So, hindi na ho kailangan ng iba pa articles?
Ang take ko dyan is, syempre, the most that you can do, try to do in the shortest time possible. And ang sinabi nila, sana before Holy Week. In fact, before March 12. Parang yun, parang ganon. Kung magagawa nila yun, that's the best. Kasi you cannot rely rin lang naman on Article 2.
Before March 12 ng lahat ng articles?
Yes.
Ng prosecution.
Ibig sabihin ko ng lahat ng articles of
yung
impeachment?
lahat ng gusto nila. Hindi lahat ng 8. Ang rinig ko gusto nila is 2, 3, 7, tapos 1.
Okay.
Yun ang rinig ko. So, 4, tapos na.
May reports din na hanggang 7 na lang, wala na yung 1.
Kasi hindi mo naman kailangan...
May ganun din hong reports. Anyway.
Yes.
Kasi hindi mo naman kailangan na ma-prove. Isang article lang ang kailangan mo na ma-prove para ma-convict mo yung Chief Justice.
But in that respect, yun ang sinasabi ko nga, no? The mere fact na yung mga senador hawak ang kanilang kartada, no, malapit sa puso nila, nobody can look what they're really thinking, okay? Is a risk. Kasi kapag umasa ka sa Article 2 at sabihin nila in the end, ay, fruit of the poisonous tree, lahat yan, wala. Asan ka na?
Nabanggit niyo rin po yung they're keeping their cards close to their chest. May yung call kanina ni Justice Cuevas para i-re-examine ng impeachment court, yung Rule 17, yung tungkol nga ho sa...
Objection.
Nothing left in favor of the respondent, ika nga ho niya. At sabi ni Senate President Enrile, sige, pag-usapan natin sa caucus.
There, you see?
So, meron pa po bang posibilidad na in the middle of the game, magpapalit sila ng rules o magmamodify sila ng ilan sa mga pamamaraan ng pag-object, etc.?
Kung gusto nila, pero chances are they cannot. Or they will not. The reason is talagang mababag down Kung nakita naman natin, nag-uumpisa pala yung testigo, di pa nakasalita, objection na kagad si Mr. Cuevas sa lahat ng klaseng posible, whether it's form, whether it's procedure, whether it's substantive, whether it's important, whether it's not important. Ang technique niya is basta. Di ba? Basta makita ko, di ba? Yung pinakamaliit na butas na pwede, basta mag-object ako. Bahala na kayo. Problema nyo kung di kayo marunong sumagot. Di ba? Yun ang kanyang strategy.
At si Senator Angara kanina, nagbigay na siya ng parang remedy dito sa question ni Justice Cuevas. Ang sinasabi niya na, okay, hindi kayo mag-o-object, pero pwede naman kayo mag-manifest ng inyong reservation.
And that's what they're doing. That's exactly what they're doing. Kaya yung sinasabi na nababiolate ang rights, not really. Kasi yung mga senador na gustong tingnan yung panig nila, talagang kakampihan sila. Ganun sila eh. In an ordinary court, okay, kung sa kuhukuman nito, yung huwes, magde-decision then and there sa motion ng kabila. Sabihin niya, motion to strike out, motion to quash, huwag papasukin yung testigo. Then and there, mag-decision yung West.
Dito lang kasi ang dami nilang judge, Professor, ano?
At I think it's their strategy, kasama na sa politics, no? Na ang strategy nila, huwag paalam sa ngayon. Pero if you notice, dahil ang gusto nila, isahan na lang yan sa huli. Now, in a way, that is good. Kasi hindi cluttered, na kundi madde-delay lalo yan. Pangalawa, more importantly, dahil pumasok ang Supreme Court sa eksena, di kapag magro-ruling sila ngayon, pwedeng dadalhin sa Supreme Court yan, di ba? Hindi natin malalaman na mayari, lalo magkakagulo. So in a way, in the sense na hindi sila nagde-decision sa maliliit na yan, at bandang huli na lang, hindi makapasok ang Supreme Court, di ba? Pero hindi aakyat nila yan, aakyat eh.
Pero magmamatter pa ba kapag sinabing, ito is strike out ito from the records, ito we have reservations on this, wag itong i-admit into evidence. Magmamatter pa ba yun sa decision ng Senator Judge kung narinig na, lumabas na naman? Sinabi ito ni Senator Jinggoy Estrada kahapon na parang, kahit hindi pa yan i-admit in evidence, ano pang magagawa natin? Narinig na, lumabas na sa publiko, narinig na rin namin.
Tingnan mo yung TRO sa dollar. Alam naman natin na ang gusto ng taong bayan, makita talaga yan. Pero nung sinabi ng Supreme Court, ayaw namin. Ano sinabi ng Senado? Rerespetuhin namin kayo. You see? In other words, the senators can do what they want in spite of the people if they want. Hindi ba? Kaya nasa sa tao na yon na paratingin talaga ang gusto. Dahil kung gusto nilang pasaway, that's what will happen. And they already showed it. Yan ang nangyari sa TRO. Wala naman silang basihan. Wala pang ruling eh. Di ba? Sinabi ba nila na tama yan? Yung salvation, yung China Bank, sa kaya ehersito, not applicable. Sinabi ba nila? Hindi. Nakabitin eh. And yet, ang desisyon, rerespetuhin namin kayo. Bakit? Ano ang dahilan? We don't know, but they did it. See? So, yun ang totoo nun. Yung, hindi masasabi na, porque ito ang tama, ito ang mali, yun ang masusunod. May kasamang, ano ba sasabihin natin? Politika?
At kailangan din ho natin tandaan na marami din sa mga senator judges ang hindi abogado. Di ho ba na kahit sabihin mo, excluded tong evidence na to, pero like Senator Estrada, for example, openly sinasabi niya, naniniwala ako na hindi peke itong dokumentong ito.
Tama. Or Senator Trillanes, who is saying, ang pamantayan ko lang dyan, may tiwala pa ba ako o wala? Is he still fit to continue or not? Yun ang sinasabi niya. Nakahuli-hulihan niya ng basehan ko. Yung ibang senador, pwede ba siya sabihan na, Brad, hindi lang yan. Brad, dagdag mo ito.
Pero siya, basta, yun lang, is he fit to be Chief Justice?
Pero, Professor, meron pa hong pending issues sa Supreme Court, yung tungkol nga sa pagpapatigil ng the entire process. Ano na ho sa tingin yung nangyayari dyan sa diskusyon na yan dito sa Korte Suprema?
Okay.
Will the Supreme Court act on that?
Parang nabinbin no? Dahil ang mas urgent na inaktuhan nila ay yung tungkol dun sa dollar accounts. Ang bilis ng desisyon nila doon.
Pero hindi nila pinigilan yung impeachment trial.
Oo, pero dito sa pagpigil, yung motion, yung mismong inihain ni Chief Justice Corona, medyo natagalan yung kanilang desisyon doon.
Doon mo makikita, if you ask me, na may impact ang pakiramdam ng taong bayan dyan sa Supreme Court. May
public
impact.
Perception.
Oo. At understanding. Ang Supreme Court nag-iingat din na hindi nila basta-basta aapakan ang karapatan ng mga tao na malaman ang nangyayari dito. Kasi kung gusto nilang itigil ito, they could have done it immediately, di ba? Pero syempre, nag-iingat din sila, baka may backlash eh. Kasi ang implication talaga nun, wala nang iba pang remedyo ang taong bayan. Wala na. Kasi kahuli-huli yan ang impeachment eh. Hindi mo pwedeng idemanda ang mga impeachable officers kasi immune. Hindi pwedeng civil case, hindi pwedeng criminal, hindi pwedeng administrative. Hindi mo pwedeng dalhin sa ombudsman yan. Hindi mo pwedeng idemanda sa Sandigan Bayan. In fact, you cannot strip them of their license kung abogado sila. Administrative case, hindi mo pwedeng ipadisbar yan. Hindi. Immune. So impeachment lang talaga ang remedy para sila maalis sa pwesto at pagkaalis sa pwesto, saka mo idedemanda.
At kapag nagkaroon ng kapangyarihan yung Supreme Court na ipatigil ang isang impeachment trial,
that means yung parte na yun ng saligang batas nawala. Nabura. Kasi all they will say is the impeachment should stop because 1, 2, 3, 4. Anong gagawin mo? Motion for recon, denied. Kung ang pakiramdam mo may mali doon may pupuntahan kang anghel, pupunta ka sa langit.
Mas mataas sa Supreme Court, wala na.
So it's a very grave step kung gagawin nila yon. Dapat may matibay silang basehan. And it happens na ako, ang position ko, hindi. Wala silang basehan para makialam sa impeachment.
Okay. Balikan ko ho, attorney, itong Article 3. May mga sub-paragraphs din ho ito. 1, 2, 3, 4, 5. Ito hong Article 2, nagka-problema sila sa 2.4
Yes.
Ito ba may kaka-problema sila in any of the sub-paragraphs ng article?
Titingnan natin, ha?
Ito ho, alimbawa, itong, I guess we can call this 3.1. Respondent previously served Arroyo as her Chief of Staff, spokesman when she was Vice President, Chief of Staff, Acting Executive Secretary.
That is in respect of number 1, yung flip-flopping, dahil sa sulat ni Attorney Mendoza.
Paano naging related yun?
Kasi tulad halimbawa nito, ang sinabi ni Senate President Enrile, ine-expand niyo yung impeachment complaint ninyo.
Okay, very good question.
Ninyo.
Ang tingin ko rito, Ivan, may connection ito dahil parang ang pinapakita niyang 3.1 na yan, etc., is yung background. Kasi, kumbaga, bakit mo pagbibigyan si Attorney Mendoza at nagre-reflex yun sa'yo bilang Chief Justice? The reason is merong background, merong pinanggalingan. And that is the relationship between President Arroyo and the Chief Justice. Merong kang, kumbaga, history of loyalty.
Yes.
Kaya ka naging loyal kasi, yan, matagal mo nang naging boss sa iba-ibang capacities. Spokesman.
Pero kanina, yun din yung sinasabi ng prosecution panel na kaya raw nila pinepresent itong Vice President for Sales ng PAL ay gusto nilang ipakita na nakakuha nga ng favors itong si Chief Justice at ang asawa niya from PAL. Therefore, kaya nag-flip-flop doon sa decision.
Yun na nga
Pero dininay ni Senate President Enrile yun kanina.
Ang sinasabi kasi dito sa 3.1 is yung relationship ni Chief Justice Corona kay President Arroyo. Hindi yung relationship niya sa PAL.
Sa PAL.
Kasi yung sa PAL, parang kuwan na lang yan parang effect na lang yan No? Effect. Shall we say, ganito yun ang cause and effect, pwedeng chicken and egg It doesn't have to follow na una yung isa. Pwedeng resulta na lang. Halimbawa, kung totoo na kaya nag-flip-flop si Chief Justice sa FASAP is dahil may pabor na parating pa lang, you see? So, alin doon ang cause, alin ang effect? Parang nauna yung effect, nahuli yung cause. Pero ang totoo niyan, baliktad, di ba? Ang cause ang nauuna, saka nahuhuling effect, no? Oo. Pero pwedeng ganun ang mangyari dahil understood, parang bibigay ko ngayon ang pabor sa'yo, susunod naman yung pabor mo sa akin. Pwedeng ganun
Isa pa hong kino-question dun sa at least sa pagkakasulat ng articles, meron, they use words like reported to have amassed, kaya ho in-exclude yung ill-gotten wealth dun sa Article 2. Ito ho, may nakita ko dito sa paragraph, under suspicious circumstances.
Okay.
Yung pagsusulat ng articles na ganyan, gaano ho ba siya dapat ka-specific, gaano siya ka-technical, if I may use the word? Paano ho ba yung tamang pagsusulat ng articles para hindi dumaan sa mga ganong questions?
Okay. In the first place, ang sabi natin, ang rule ay dapat merong ultimate fact. Ang fact ay kung anong nangyari, hindi opinion, hindi conclusion. Okay. Which brings me to Article 2. Okay. Kasi yan ang sinasabi ng depensa, no, na ang 2.4 ay conclusion, suspicion, report. Hindi totoo yun. Dahil merong word doon na accused. So sinasabi ng prosecution, the respondent is hereby accused. Ngayon, pag sinabing accused, yan ang reklamo sa'yo. Yan ang bintang sa'yo. Pinagbibintangan ka ngayon. Okay? So, insofar as 2.4 is concerned, I think may konting inaccuracy doon sa pagkaka-appreciate ng 2.4. I think there was an allegation of fact there. Okay? Pero pagdating dito sa 3 anong section ba yan sinasabi mo, Ivan?
Itong last sub-paragraph ho sa Article 3.
Yes. Respondent Corona
irregularly dismissed the Interpetal Recreational Corporation case under suspicious circumstances.
Anong numero?
3.5?
3.5. Kasi merong 3.5.1, 3.5.2.
Okay. So, mukhang magkaiba ho yung...
Sorry, marami talaga.
Bullets lang ho kasi ito eh.
Oh, I see. Oh my God.
Ito ho, itong under suspicious circumstances.
Tungkol sa Cap John Hay or
itong
what?
Interpetal Recreational Corporation case.
In connection with FASAP or... Sorry
Yun nga ho eh. Hindi ko ma-connecta kung alin dun sa tatlo sa main article connected itong sinasabi nila.
May isa pa akong nakita, ma'am. Ito, respondent has been reportedly using the judicial fund as his own personal expense account.
Hindi na yan Article 3. Article 8 yan. Yan yung JDF saka SAF, no? Judiciary Development Fund, saka special...
No, meron din ma'am sa Article 3. Under Article 3, may nakasulat din po dito.
Anong paragraph kaya yan? Kasi wala dun sa main, ano? Yung main, yung title niya mismo, sinasabi, in allowing, yung sa FASAP. Tapos yung isa, in creating, yung entanglement sa John Hay. Yung ikatlo is in discussing with litigants. So, alin kaya dyan papasok yung sinasabi?
Anyway, going back to my question, meron po bang proper way of phrasing an article such that hindi humantong dun sa gaya ng 2.4 na in-exclude na altogether? Dahil because of the use of the words suspected of having accumulated ill-gotten wealth.
Okay, 2 points, 2 points. I'll go to your main question.
Okay, sige.
Kaya lang, I really have to clarify.
Go ahead.
Because ang 2.4 was not excluded in the sense that you may not consider it in deciding the case. No. What happened is, what is excluded is evidence regarding ill-gotten wealth. Okay. So, in other words, ang point lang ng korte is, pag pumasok ang basihan mo, ang mga facts mo, ang ebidensya mo, pag pumasok under 2.2 and 2.3, okay, at lalabas yung elemento ng ill-gotten wealth, then the law itself will conclude na may ill-gotten wealth. And bilang huwes, under the doctrine of judicial notice, you must apply the law. Kung ang law nagpe-presume na ill-gotten wealth, dapat mag-presume ka. Diba? Dahil bilang huwes, sundin mo ang batas. Okay, yan ang 2.4. Pagdating naman natin doon sa ultimate question mo, ang kailangan sa isang reklamo o kailangan din sa isang answer, yung sumasagot sa reklamo, ay ultimate allegations of fact. O allegations of ultimate fact. Sa makatwid, sabihin mo lang yung pinaka diretsahang expression ng basihan mo sa reklamo mo. Paano natin malalaman kung ganun ang ginawa mo? Okay? There is one simple practical way of doing that. Ang doktrina ay ganito. Granting or hypothetically admitting, ipagpalagay na nang sinabi mo, 1, 2, 3. Yan, isang paragraphs mo yan. Pagpalagay na totoo lahat yan, mananalo ka ba? Pag mananalo ka, then complete. Okay? Then okay ang pagkakasabi mo. Pero kung merong kulang sa sinabi mo, pagpalagay na totoo lahat yan, kahit totoo lahat, kulang ang elemento ng reklamo mo, talo ka. Yun ang lumalabas na hindi kompleto, no, ang sinabi mo. So, ang kinakailangan talaga, ang ina-allege mo, fact, kung anong nangyari. Hindi pwedeng conclusion na, pag halimbawa, sinabi mo, ikaw, may utang ka sa akin, period. Ay, hindi ka mananalo nun. Dahil ang tanong paano ako nagkautang sa'yo? So, you have to say it. Nung araw na yon, inabutan kita ng ganitong pera. Tinanggap mo, at kaya mo tinanggap ay utang yun. Utang yun dahil babayaran mo ko uli. At pagkatapos mayroon pang interest. Kailan babayaran? Sa ganitong petsa. Kaya kapag siningil kita, di mo ka binayaran, may utang ka. Ganon.
So
Yun
hindi
facts.
naman ho fatal flaw yung use of words like suspected, reported.
Dagdagan mo. Hindi pwedeng yun lang. That's why I was saying sa 2.4, meron yung word accused. Enough yun. No? Binagbibintangan ka ngayon na ginawa mo yan.
Pero yung title, kailangan hanggang dun ka lang sa title. Kung ano lang yung sinasabi ng title, hindi...
Baliktad. Ang title is just a label.
A label.
Yeah.
Ang mas importante, yung explanation.
Yes, yung nasa allegations of fact, sa paragraphs. 1, 2, 3, yun. Yun ang titingnan talaga. Yun ang binding. Sa hukuman, yun ang talagang basihan kung ano ang pwedeng ebidensyang ipasok mo o hindi. Kasi yung ebidensya pinapasok, para lang pruebahan yung sinabi mo. Yung allegations of fact. Oo. Kaya nga sinasabi ng
So,
depensa.
pwedeng wala sa title, pero nasa explanation.
Yes. Yes. Yung
dapat
allegation.
talakayan pa rin.
Pwede ka magpresenta ng ebidensya.
Kung ganun po, bakit hindi tinanggap itong Vice President ng Philippine Airlines tungkol dun sa pagtanggap, di umano, na mag-asawang Corona ng travel privileges?
Nandito
when
pa
it
sa
is
laman
alleged
yun.
sa 3.4.6.
Sandali lang.
Ito ho yung na... I came across this article. The new Code of Judicial Conduct further provides that it is unethical for a magistrate and members of his family to ask for or receive any gift in exchange for any act.
Ay, nako. Therefore, bawiin natin yung sinasabi natin. Then I am sorry, I have to correct myself. Kasi hindi ko nabasa yung paragraph na yan bago ko nakita yung title ng Article 3. Okay? Having read this now, Ivan, I have to, Kara and Ivan, I have to go back to the previous doctrine I've always adhered to, even in respect of Article 2.
Okay.
It is not the title that should prevail, it is the body. So kung ganyan palang merong 3.4.6, at sinasabi niya tungkol sa gift in exchange for,
Na yun ho yata yung purpose ng pagpresenta ng Vice President for Marketing ng Philippine Airlines.
Halata. Therefore, dapat papasok yun.
Pero parang lumalabas ngayon sa Senate na mas binibigyan nila ng halaga yung title. Katulad dun sa Article 2 na hindi pinayagan yung sa ill-gotten wealth na paragraph because it's not in the title.
If you ask me, kaya siguro sila nagko-caucus ngayon, nagsesession sila. Kaya siguro, I'm not sure pero baka kaya nagsususpend ng session. Kasi remember, ilang beses nangyari yan Katulad nung nagde-debate tungkol doon sa original. Hindi ba, nung una ayaw payagan yung original Sinasabi na, basta peke yung Xerox, period. Nung ang ibang senador sinabi, teka, mukhang may basehan yata para tira original to test the credibility, blah, blah. Pansinin nyo, ilang beses sila nag-session. Diba? Yeah. At ang katapusan nun, pinayagan yung original. Diba? At lahat ng mga senador, sinilip na rin. You see? So, I think pagdating sa mga very important questions na yan, nagsisession sila. Kasi hindi rin papayag yung ibang senador na, kumbaga, may importante talaga at isa lang nagdesisyon, yung presiding officer. Hindi pwede yun Kasi siya, kumbaga, manager lang siya ng proseso. Administrative lang ang duty niya. Hindi siya ang buong korte.
At maliban ho dun sa marami din ng mga ang abogado sa mga senator judges and lawyers, of course, can have opposing opinions on just about anything.
Bakit, ang question in my mind, bakit hindi pinoint out ito kanina ng prosecution panel
Yun
when
din.
they were defending their position?
Si Congressman Tugna, in particular, bakit ho hindi niya kaya na-raise ito?
Oo, ang sinasabi niya is, we pointed out to partiality. Sabi niya Article 3 refers to partiality. Pero hindi niya sinabi 3.4.6. No?
Had he said 3.4.6?
Yeah, mas matibay. Mas matibay ang basihan. Kita mo, pati ako nalito di ba? Sabi ko,
At i-argue nila na hindi dapat mag-focus sa title.
Yes. It's the same thing all over again, just like Article 2.4. It's the same. And it's a very crucial point. Yeah. Kaya siguro nagdedebate na naman sila ngayon.
Pero babalik na naman ho ko doon sa pagkakasulat ng articles of impeachment nila mismong si Congressman Fariñas sabi niya medyo masama daw pagkakagawa.
Siguro yung title. I will agree with you. Medyo hindi perfect yung title ng mga articles. Pero yung laman, yung loob.
So ideally, dapat yung title, ang ginawa na lang nila, hindi masyadong specific. Parang in-state nila in broad terms, tapos saka ka nag-explain ng specifics. Ganun ba?
Naman, kasi the reason why merong ganong title is para isang tingin lang naintindi ng senador. Diba? Itong Article 1, ano kaiba sa Article 2? Diba? Kasi kung titingnan mo, lahat sila, betrayal of public trust, culpable violation, diba? So kung hindi mo in-specify, magkakamunta ulo yung senador lalo. Sabihin, lahat naman to betrayal eh. Right, no? So, siguro, yun na nga, siguro, ang gusto nila paigsiin yung title. But, yun na nga, hindi nila akalain, sobra naman kasi napaka-technicalidad ng defense, no? Siguro kung alam nila na gano'n ang mangyayari, inisa-isa lahat sa title. kahit ganyan kahaba yung title, no? Para lang walang ganong problema.
But at the rate we're going, Professor, mukhang matatagalan din itong Article 3.
Actually, ang dami.
First witness, technically second witness nila to for Article 3, ano? Ito na nabara na naman sila.
Alam mo, ang tingin ko, bumabalik sila sa first witness eh. Palagay ko, pinagdedebatihan nila yung first witness.
Yung Vice President? No?
Yun, dahil doon sa puntong yun.
Siguro, ipupush pa rin nila.
So you think pwede pang makaupo ulit itong Vice President ng PAL?
Kung magbago ng desisyon. Kasi remember, ang nagdesisyon lang si Senate President. Siya lang, nag-iisa.
The chair has ruled.
Right. Siya lang. Kung sabihin na ibang senador, teka, major point ito, dapat buong Senado to. Paano kung ganun? Ay, di pwede siyang i-overturn talaga. In fact, that's what the Senate President said. Di ba sabi niya, if you want, bring it to the court. Di ba sabi niya? Ang ibig sabihin nun, hindi sa magmo-motion for recon ka, hindi. Kundi, i-invoke mo ang dapat mag-rule yung korte.
Which means, divide the court.
Kaya nagsisession sila, I think. Ganun na nangyari sa 2.4, di ba? It's all of them. Di ba? Hindi lang isa.
Pero ito talagang nag-rule si Senate President Enrique.
Nag-rule siya in a way, but with one phrase na sinabi niya eh. If you want, bring it to the court.
Ito, Professor, malalaman natin kung paano nga re-resolbahin ito. Magbabalik po tayo sa Senado. Balikan natin ang impeachment proceedings.
Good afternoon, Mr. President.
Yes.
Can we just be allowed to make a short manifestation, Mr. President?
Proceed.
Thank you so much. Mr. President, this is regarding the exclusion of the testimony of the witness from the Philippine Airlines. We had the utmost respect to the Honorable Presiding Officer. The prosecution takes exception to the ruling regarding the matter. And it is the position of the prosecution that with the presentation of the witness from PAL, the prosecution does not expand the complaint as stated.
Why not?
For the following reasons, Mr. President. As to the relevancy to the Article 3, it proves consideration, inducement, motive. To us, the motive here is very, very important, crucial, critical to an impeachment proceeding. The motive for what? The motive for the Chief Justice in flip-flopping. The motive why the Chief Justice acted on a mere letter based on paragraph 3.3 of the article. The motive why the Chief Justice involved in the administrative matters that are alleged. So we allege here the flip-flopping, Your Honor. We allege the mere acting on a letter by Attorney Mendoza. But to us, it is very important to prove the motive in an impeachment proceeding.
You should have alleged bribery. If you understand the meaning of bribery.
Yes, we did not allege that, Your Honor.
Precisely, but that is the tendency of the evidence that you are presenting.
But, Your Honor, the very heart of Article 3 is integrity, providence, and independence.
Correct.
Probity.
Correct, but you limited your charge for lack of competence, probity, and integrity in 3 ways. Mr. Counsel, I do not know how you learned your art of pleading. I do not fault you, but I'm basing my ruling on your allegations and nothing more. And if you are going to insist on your position, I say I will not change the ruling.
We respect that, Your Honor. Can I just finish my manifestation
Now,
with the utmost
you
respect?
want me to order you to amend your articles of impeachment and send it back to the House?
We wouldn't know, Your Honor.
You have a choice.
We respect that, Your Honor. But it is, I just want to finish, Your Honor, that
Yes.
technicalities cannot be permitted to prevail in such an important proceeding.
This is
such
not
as,
a
this
for heaven's sake,
impeachment
this is not
proceeding.
a technicality. The grounds for impeachment are very clearly stated in Articles 11 of the Constitution. We are already very liberal. You're in effect asking us to review the decisions of the Supreme Court. Who are we to review the decisions of the Supreme Court? But we allow it in order not to embarrass you. But you are going too far.
We respect, of course, we have a very high respect.
Do you want me to lecture to you more?
No need, Mr. Presiding Officer. Anyway, Your Honor, that is we just want to put that on record as the position of the prosecution.
Well, I
That's
will tell
all.
you, if you want to allege the receipt of gifts, the receipt of valuable things by the respondent, then amend your articles of impeachment, because you are in effect alleging a crime, which we will have to evaluate whether it is a high crime. You are in effect alleging that he was bribed to make that decision.
Yeah, but Your Honor, the charge here, the ground is betrayal of public trust. Anyway, Your Honor, thank you for that, for giving us opportunity. We just want to thank the Honorable Presiding Officer for giving us that opportunity just to state for the record the position of the prosecution on the matter. And now, may we request that one of our private prosecutors be recognized again. Attorney Marlon Manuel.
Attorney Marlon
Manuel, Your Honor.
Manuel.
Thank you.
Proceed.
Thank you, Your Honor. We will make a tender of excluded evidence, Your Honor, under Rule 132 of the Rules of Court. And we would like to state for the record that if had PAL Vice President for Sales, Enrique Javier, been allowed to testify, he would present the following documents, which were required to be submitted pursuant to the subpoena that was issued. First, Your Honor, and this was previously marked as Exhibit Septuple P, this is a certification and compliance signed by Enrique P. Javier, saying that Platinum Card number A752 was issued in the name of Corona Renato C. The date of issuance is December 2010, and the expiry date is December 2011.
Your Honor, please.
Well, wait a minute. I will allow the manifestation. What is the pleasure of the...
Yes, Your Honor. Thank you very much, Your Honor.
Well, practically, this is adducing evidence through a manifestation, Your Honor.
This is a tender of excluded evidence, Your Honor.
The proper of evidence, Your Honor, is proper only when there is a witness on the stand and a question had been propounded to him, thereby, and an objection is made, thereby sustaining the objection, so that if the witness was not prohibited from further testifying, then the counsel, his counsel, or the counsel conducting the examination may make a proper of evidence. That is the situation where that rule applies, Your Honor.
Your Honor, may we be allowed to respond?
Yes.
Under Rule 132, Section 40, if the evidence excluded is oral, the offeror may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. So this is precisely the situation that we have now.
Your Honor, please.
We have discharged the witness.
Yes, Your Honor. That is why we are making the manifestation for the record on the substance of the testimony of the witness.
This is if Your Honor, please, this is unprocedural. This is violative of the cardinal rules on evidence, Your Honor. As we have stated, that can be done only when there is a witness on the stand, there is an objection, and the objection is sustained. So there could be a proper of evidence.
Anyway, counsel, even if I allow the matter to remain in the record, it is to me it's not evidence yet. So, let it be.
Thank you, Your Honor. Your Honor, based
what
on...
is a platinum? I don't understand what is a platinum.
Yes, Your Honor. A platinum card, Your Honor...
No, you cannot state it for yourself.
I am not stating it, Your Honor.
You're not under oath.
Yes, Your Honor. But I am referring to a record showing the benefits of a PAL platinum card. And this is based on the certification...
That is improper for counsel to state. You should have presented a witness for that purpose.
Your Honor, I am referring to an annex of the certification of the witness. This was already marked, Your Honor.
Let it stay as it is. The ruling of the chair stays.
So may we be allowed to continue with the manifestation, Your Honor? The PAL Platinum card was used based on the certification and compliance for 4 round-trip travels. 1, Manila-Guam, Guam-Manila, dated April 20 and April 24, 2011, respectively. Manila-Singapore, Singapore-Manila, April 15, 2011 and April 19, 2011, respectively. Manila-Honolulu and Honolulu-Manila, December 25, 2010 and December 30, 2010, respectively. Manila-Hong Kong and Hong Kong-Manila, December 18, 2010 and December 21, 2010, respectively. And then the platinum card number A753 in the name of Corona Maria Cristina R. Date issued December 2010, expiry date December 2011. And there are 12 round-trip travels recorded in the certification and compliance. Manila, Jakarta, Jakarta-Manila, July 10, 2011 and July 15, 2011 respectively. Manila, Guam and Guam, Manila, April 20, 2011 and April 24, 2011 respectively. Manila, Singapore and Singapore, Manila, April 15, 2011 and April 19, 2011 respectively. Manila, Bangkok and Bangkok, Manila, March 4, 2011 and March 7, 2011 respectively. Manila, Honolulu and Honolulu, Manila, December 25, 2010 and December 30, 2010 respectively. Manila, Hong Kong, Hong Kong, Manila, December 18, 2010 and December 21, 2010 respectively. Manila, Bacolod, Bacolod, Manila, July 28, 2011 and July 28, 2011, same dates. Manila, General Santos and General Santos, Manila, June 3, 2011 and June 4, 2011 respectively. Manila, Cebu and Cebu, Manila, March 18, 2011 and March 19, 2011 respectively. Manila, Tagbilaran and Tagbilaran, Manila, March 22, 2011 and March 24, 2011. Manila, General Santos and General Santos, Manila, March 2, 2011 and March 3, 2011. Manila, Cebu and Cebu, Manila, February 15, 2011 and February 16, 2011. Your Honor, Annex A of the certification and compliance refers to the benefits of the PAL Platinum Card. And may I read for the record?
The document speaks for itself.
Yes, Your Honor.
All right.
Your Honor, in that case, may we make a manifestation
yes,
that had...
You'd like to just present the evidence. You have already marked it as a exhibit, you said, so be it.
This was marked as
the contents of the document is the best evidence. You cannot add anything to it.
Yes, Your Honor. Septupol P-4, Your Honor, is the passenger name record BZFUMN in the name of Corona Renato Mister, Corona Maria Cristina MS. Exhibit Septupol P-5, Corona, passenger name record CFFTE2, Corona Renato Mister. Septupol P-6, Corona Renato Mister, Corona Maria Cristina. Passenger name record C6QIWN. Exhibit Septupol P-7, passenger name record BKEHT6 in the name of Corona Renato and Corona Maria Cristina. Exhibit Septuple P-8, passenger name record EHIZDW in the name of Corona Maria Cristina, all with indications of business class and the use of the platinum card, Your Honor. We have also marked as exhibit Septuple P. Okay, Your Honor, those are referring only to the names in the passenger name record.
Are you true?
If Your Honor, please,
Yes, Your Honor.
Just a minute. You're offering this under Article 3.
Yes, Your Honor.
But you have not alleged any bribery. Isn't it, under Article 3?
We have alleged...
No, you did not answer my question. You did not allege bribery.
Not bribery, Your Honor.
All right. Finished.
If Your Honor, please. On the part of the defense, Your Honor, we move to strike out any and all manifestations made together with the documents now marked as exhibits, Your Honor. And this is the purpose, Your Honor. This is allegedly offered pursuant to the rule on proper of evidence, Your Honor. We are in conformity with counsel that this may be done, but not in this particular situation, because here there is an allegation under the article of impeachment, and the evidence is being presented not in accord or to sustain that. There is nothing in the article of impeachment which will cover this particular matter, Your Honor. So the proper of evidence is highly improper and should be excluded at all costs, Your Honor. Because first, the manifestation was made not under oath. We cannot accept the veracity, authenticity, and accuracy of what is being introduced into the records. The manifestation was made by counsel. He is not under oath. He can be a witness if he wants to, Your Honor, so that we can cross-examine him. But this is not a case of not being able to answer a question because there was prohibition by the court. This is a case where there is an impeachment article and the evidence so to be presented is not embraced in that particular article. So this is decidedly illegal, Your Honor. It has no probative value whatsoever.
Anyway,
Thank you,
counsel, I think you and I understand that this evidence is nothing because it assumes something that is not established yet. So let it remain in as a manifestation of counsel, and it will be appreciated by the members in whatever they wish, but we will discuss this in due time.
Thank you, Your Honor.
You know, with due respect to the members of the prosecution panel, this presiding chair has been very lenient. I tried to help you. But there is a limit to what this presiding officer can do. If your articles of impeachment are defective, that's your responsibility. You made an allegation, a specific allegation, charging the respondent with lack of probity, integrity, and so forth and so on. And you stated the basis of your conclusion. Your statement that he does not have competence, probity, integrity, and what else? And independence is a conclusion of fact based on what you want to prove. And now you're offering a stranger in paradise to prove an allegation that does not exist in Article 3. That's why I consider this a trust. So let it be a part of your manifestation if you want to. Proceed. Next witness. You present your next witness.
Yeah, Mr. President, just 1 minute recess, please.
Okay, 2-minute recess.
Thank you.
prosecution panel na tanggapin pa rin yung Vice President ng Philippine Airlines para tumistigo dun sa mga
Attorney
travel
Avena,
privileges.
pwede pong paki-explain sa amin kung ano po yung ginawa ni Attorney Marlon Manuel. Bakit po kailangan na basahin po niya kung ano
Into the
yung
record?
into the record yung na-exclude na evidence po?
Kasi may tinatawag na tender of excluded evidence na procedure sa rules of evidence, no? Although ang sinabi ni Attorney Cuevas, if you noted, sabi niya proffer of evidence. Yun ang lumang term, okay? Ang bagong term is tender of excluded evidence. At nangyayari yan kapag ganito. Mayroong testimony na inobjektahan ng kabila. Kaya ang nangyari, kapag ang korte ay pumayag doon sa pag-object, no? Sa makatid, hindi pumasok yung ebidensya, yung procedure na yan sa rule of evidence, ay sinasabi na, ito ang gagawin mo. Ito ang pwede mong gawin kung hindi pumayag ang korte dahil pumayag sa objection. Ang gagawin mo ay sasabihin mo, may I therefore make an offer or a tender of excluded evidence. Meaning to say, pwede ko bang to read into the record, Your Honor, kung ano sana ang sasabihin ng testigo kung hindi na-exclude ang testimony niya. Okay. So pag sinabi mo yun, Your Honor, may I make a tender of excluded evidence, sasabihin mo ngayon yung pangalan ng testigo, ano yung personal circumstances niya, at ano yung substance ng testimony niya kung pinayagan siyang maupo at magsalita.
Bakit po kailangan pa yun?
Ano yung value pa nun?
Ano pa yung value nun? Sinabi na po ng judge na hindi ito pwedeng paupuin itong witness na ito at hindi naman ito relevant sa kaso. So bakit kailangan pang basahin?
Kasi merong such a thing as appeal. So ang korte pwedeng nasa mababa yan, meron sa susunod, halimbawa yung municipal trial court, merong regional trial court, yan ina-appeal yan sa Court of Appeals hanggang sa Supreme Court.
Pero may appeal po ba sa impeachment?
Wala nga, pero yung mga senador, remember ngayon, proceeding to, no? Kaya nga pag on the record yan at pagkahuli-hulihan, magde-decision na sila at ang kanilang caucus or session ay lalabas na ang resulta ay, sige nga, papasukin na natin yan, yung ebidensyang yan. Di pwede nang i-consider kung nasa record. Kasi kung hindi mo yan ginawa ng tender at wala sa record, ano pang titingnan nila? Tatawagin. Pagdating
pwede pa yung ipasok, ma'am? Kahit na sinabi na nag-rule na ngayon na hindi siya ipapasok? Pwede pang later on in the game ay pwede pang ipasok yung evidence
nasa
na yun?
Nasa senador yun, oo. Yan ang silbi ng tender. Kasi kung sa korte, pagdating ng appeal, kapag sinabi ng appellate court, teka, mali yata yung in-exclude mo eh. Dapat yata pinapasok yan eh. On appeal, pwedeng i-remand o kaya pababalikin sa lower court. No? At sasabihin, Mr. Judge ng, let's say, RTC, tawagin mo yung testigo na yon at patestiguhin mo. Kasi nga, nire-reverse namin yung exclusion. Or, yung mismong Court of Appeals, meron niyang power to conduct trial and try the case mismo. Conduct hearing. Kaya sila mismo, kung may oras sila at gusto nila, sila mismo tatawagin nila yung testigo. O yung na-exclude na testimony mo, mali yun. Nire-reverse namin ngayon. Tinatawag ka namin. Sige, tumistigo ka na.
So,
ganon.
In this case, a senator judge can recall an excluded witness?
Nasa sa kanila yun. Kasi
pwede ho nilang gawin yun?
Wala sa rules. Wala sa rules. Kaya ang tingin ko dyan, kaya nga, ang nangyari dyan, ni-record na lang, di ba? Nire-record na lang. Ngayon, kung sa end at magde-decision nila at gusto nilang sabihin na mali yung pag-exclude na yun eh. Kailangan papasukin natin yan. Pwede gano'n mangyari. Magko-caucus na naman sila, di ba? O magsisession na naman sila at di-decision na nila yan. I-consider ba natin o hindi? Pwedeng ganon o kaya as usual, bitin. Pwede sabihin nila, bahala na kayo. Di ba? Isa-isa kayo, bahala kayo mag-decision kung i-consider nyo o hindi. Ganon ka-open-ended ang rules eh.
Pero
sorry.
Professor, mukhang sinigundahan o sinuportahan ng mga senator judges yung ruling ni Senate President Enrile.
Well,
wala ho tayong narinig na senator judge na tumayo para questionin yung ruling.
Totoo. Pero remember na, tama talaga yan, Pero remember na mayroong mga occasion in the past na bagamat nag-rule na yung Senate President, bigla na lang nare-reverse sa susunod na hearing, iba na nangyari. Kasi sa caucus, tinitake up nila. So we really don't know if they will still take it up on caucus. Wala silang ganong rule na pag sinabi ng PO, tapos na yon. Pag sinabi ng presiding officer, yun na yon. Nababago nila yan, depende sa caucus nila eh. So it's really up to them.
Okay, nag-resume na po ulit ang impeachment trial. Balikan po natin ang Senado.
Witness has not been able to testify today. We are constrained and this we asked most humbly, Your Honor, to ask for a continuance of the hearing till tomorrow, Your Honor.
We have no objection, Your Honor.
Until tomorrow?
Tomorrow, Your Honor.
Well,
2 o'clock, Your Honor.
Well, I would like to explain to the public that the discharge of your witness, because his testimony was considered irrelevant with respect to the allegations of Article 3, is not the fault of this court. It was the fault of your way of presenting your case and in making your allegations in your articles of impeachment. Okay?
Yes, Your Honor.
The requested continuance is approved.
Mr. President.
Majority Floor Leader.
Yes, Mr. President, we are in receipt of the explanation of votes of Senator Pimentel and Senator Pangilinan. I move that we include it in the record of the impeachment court.
Let those explanation of votes be included.
May we ask the Sergeant at Arms to make an announcement, Mr. President?
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President, I move that we adjourn until 2 o'clock in the afternoon of Wednesday, February 22, 2012.
Any objection? Hearing none, the trial is adjourned until 2 o'clock in the afternoon of Wednesday, February 22nd, 2012.
Nag-adjourn ang impeachment trial ngayong araw na ito, araw na Martes. If you remember, Kara, last Tuesday, maaga rin nag-adjourn pero dahil sa dalawang okasyon. Valentine's Day at birthday ni Senate President Enrile. Pero ngayon, mukhang nagtapos yung pagdinig na mainit ang ulo ni presiding officer.
Oo. At bago po tayo magpaalam, okay, tanong pa po kay Professor Avena, ano pong masasabi nyo sa takbo ng paglilitis ngayong araw na mukhang ang ina-expect nila makakapag-testify kasi itong witness nila yung Vice President ng PAL, no? Tapos dahil hindi nga nakapag-testify ito, wala silang naihandang iba pang witnesses.
Yun ang nangyari.
Kaya natapos ng maaga.
In the interest of candor, I looked again at what you said. No, was the possible paragraph na basis nung sinasabi ng prosecution. I.e., you mentioned paragraph 3.4.6. Okay.
0.6. Yes.
Correct.
Binasa ko yan. Nakasandwich yan sa 3.4.5 at 3.4.7. Yeah? Okay. At yung dalawang paragraph na yon nakapaligid sa kanya ay tungkol sa Camp John Hay.
Okay.
Hindi tungkol sa FASAP versus PAL. Right? Yun. So kung ganun pala na ang konteksto ng paragraph na yan, talking about favors, no? Asking for and receiving favors in connection with the pending case or whatever. Kung yan ay wala sa konteksto ng FASAP versus PAL, kundi sa konteksto ng Camp John Hay, mukhang lumalabas uli na tama yung depensa rito at si Senate President, no? Na walang koneksyon yung allegation na yan na tungkol sa platinum card, no, through the Vice President, walang connection yan sa mga sinasabing charges sa Article 3.
So pagdating dun sa FASAP case, basta anything that has got to do with PAL, dapat ang pag-uusapan lang dun ay yung letter ni Attorney Estelito Mendoza.
Yes.
Yun lang, at yung pagbaliktad ng decision.
Yes, yung hindi decision, kundi yung resolution.
I mean yung resolution. Oo, yung pagbawi ng resolution.
Yes.
Okay.
Yun lang ang kailangan nilang i-prove doon.
So, Professor, wala na ho na tayong inaasahang babalik pa tayo sa Article 2, ano? Meron pa bang
yung reservation lang ni Attorney Tupas. Yung dalawang ni-reserve niya. Kasi meron memorandum na tungkol doon sa PS Bank President, di ba?
Okay. So, masasabi naman po natin nakausad na tayo after 21? Day 21 trial days.
Lumipat na tayo ng article ngayon. Mula dun sa... Pero yun nga po yung pinag-uusapan na ulit-ulit pong sinasabi ni Senate President Enrile na you should amend your articles of impeachment.
At karababalik na naman tayo dun sa perception na naman po. Ano? Perception. Wala ho silang naipresentang testigo kapalit nung hindi tinanggap na testigo ngayong araw nito. Kaya maaga ho tayong nagtapos. Ang perception na naman ho niyan, hindi na naman ready yung prosecution. Wala na naman silang witness na i-present.
Mali na nga daw yung pagkakasulat, tapos wala pang witness na i-present.
Alam mo, ang rinig ko, si Mr. Visconde noon nag-a-attend no? Oo. So, nangyayari yan talaga sa trial, no, sa paglilitis. Nangyayari na minsan available, minsan hindi. If I remember correctly, marami rin testigo noon sa bangko na nakahilera. At ang tagal-tagal, no, saka yung mga Register of Deeds, naalala nyo?
Yes.
Ang ilan, oo. Mula alas 8 ng umaga hanggang alas 7 ng gabi, nandun sila. So, nangyayari talaga yan. Ngayon,
These are, of course, observations that we get from social media and from other sectors. Pero like you said, nangyayari naman po yan sa totoong buhay, ika nga, ng paglilitis.
Oo. Kung meron mga pagkukulang prosecution, yung right now, yung sa drafting, noong title nung Article 3.
So you think hindi rin tama yung
title sa allegations,
Oo. So you think flawed nga yung pagkakasulat dito sa articles of impeachment?
In that respect, dahil hindi nila pinasok yung tungkol sa platinum card doon sa allegations.
Okay.
Nilimit nila yung partiality sa FASAP versus PAL tungkol lang sa letter ni Attorney Mendoza. Hindi nila sinabi na dahil sa FASAP versus PAL ay pending tumanggap o humingi ng pabor ang Chief Justice.
Ayan, tuloy at hindi na itago ni Senate President Enrile ang kanyang init ng ulo ngayong araw na ito. Ngayon po ay magpapasalamat na kami sa ating legal expert na nakasama ngayong hapon. Maraming salamat kay Professor Victoria Avena ng UP College of Law. Thank you, Professor. At yan po mga pinakasariwang balita kaugnay sa impeachment trial ni Chief Justice Renato Corona. Ako po si Ivan Mayrin.
Huwag po kayong bibitiw sa patuloy na pagtutok ng GMA News TV sa makasaysayang paglilitis ng punang maestrado ng Korte Suprema. Ako po si Cara David.
At ito ang The Chief Justice on Trial.
Nay Perla, dalawa pang soulaki. Dalawa? May pagbibigyan ako ninyo. Uy.